Why is Muhuri here? Muhuri is here because in its appeal, the AG is aggrieved with the finding that was made, in particular that the BBI bill contravened Article 10 of the Constitution on public participation. On its part, IBC appeals the findings that were made that touch on composition and quorum of the IBC. To that end, therefore, I will address this court on two issues. The first issue would be the interpretation of Article 88 and 250 in respect of composition and quorum of the IBC. And number two, what would be the mandate of IBC under Article 257(4) of the Constitution. I now move on to the first issue, which is on the quorum of the IBC. To that end, two important findings were made by the Court of Appeal. The first one was that IBC was not quorate at the time it verified and certified the BBI bill under Article 257(4) and 5. And the second one was that the IBC was not quorate at the time it developed the administrative procedures that it used to undertake and guide the verification of signatures. We have been told by the IBC that the composition of IBC ought to be 3 members as stipulated in Article 250 of the Constitution, and not as set out in the second schedule to the IBC Act. In this court, IBC further contends that the Superior Court judges disregarded the decision that was made in the Isaiah Kibiwott case. That is where we start our submissions. We submit to say that contrary to the position that has been made to this court, that the court disregarded the applicability of the Isaiah Kibiwott case, we submit that indeed both the High Court and the Court of Appeal considered in length the application of the Isaiah Kibiwott case. And in two cases, both courts held that the obligation of the IBC under Article 257 and 4 and 5 of the Constitution was not an administrative exercise, but it was a very serious and heavy constitutional obligation that was placed on the IBC with very serious implications that could not and cannot be left to a 2-member majority. The question therefore at this point would be, what would happen if at all we are to agree with the submissions of the appellant that the quorum ought to be 3 and not 5? My Lord, currently the IBC has 7 members as constituted today. It therefore means that for any decision that has to be made by the 7 members of the commission, we only need 3 as part of the quorum. That would mean that in any instance, we have 2 members that are making a decision that is going to bind the commission as well as the people of Kenya, because any function and any duty the IBC undertakes is a constitutional obligation that is placed upon it and binds every person, including any Kenyan citizen. Therefore, we submit to say that it could not have been the intention of the legislators that we would have to have a 2-member majority make decisions of the IBC. Basically, that's what it means if we are to stick with a 3-member quorum. In any event, it is not also lost to us that the Isaiah Kibiwott case was not binding on the High Court at the time it was made, because it is a court of concurrent jurisdiction. Neither was it binding on the Court of Appeal. The High Court could and actually did depart from the Isaiah Kibawat case, and it gave its reasons for doing so. The High Court gave its reasons for departing from the High Court decision in the Isaiah Kibawat case. It stated the following reasons. Number one, the High Court stated that the IBC statute did not distinguish between policy and other business. The court, therefore, in departing from the Isaiah Kibawat case, held that the IBC can conduct its business, cannot conduct its business when its composition is below 5. The duty that was placed before the IBC under Article 257, 4 and 5 to verify and certify that the BBI bill was supported by more than 1 million registered voters was a core business of the IBC, and therefore it required the majority, it required the requisite quorum, which would be 5. Number two, the High Court considered the question whether or not the BBI bill had met the constitutional requirement for purposes of Article 250. The question whether or not the BBI bill had met the constitutional obligation under Article 257(4) was a very serious obligation and required a number of 5. I've already said that in so doing, the High Court considered the peculiar history that we have in this country as far as it relates to electoral processes, and found that a 5-member commission would, a membership of less than 5 would not be the intention to make such decision, and that quorum was as stated in the Isaiah Kibawat case, and it is a critical obligation that was placed on the IBC. My Lord, there has been attempts to reduce the quorum from 5 people, 5-member commission. This was done through the amendment bill, the Elections Laws Amendment Bill of 2017, which reduced the quorum from 5 to 3. That was challenged in the Katiba case, and the Katiba case challenged the constitutionality of that amendment, and the High Court found in favor of Katiba case, and it issued an order declaring that any attempt to reduce the quorum of the IBC from 5 members to 3 members was indeed unconstitutional. That was the position as at the date the IBC received the signatures supporting to amend the Constitution, the time the IBC verified those signatures, and at the time the IBC certified that indeed the BBI bill was supported by more than 1 million registered voters. The question therefore before this court, and this court must answer, is what was the effect of the declaration of the unconstitutionality that was made in the Katiba Institute case? To answer that question, I would ask the court to find guidance in the Court of Appeal decision in the case of Javan Kiche Otieno, that is in our supplementary band of authorities, which was issued on the 17th of December 2021, a few weeks ago. In that case, the Court of Appeal sat to address a similar issue on what would happen to the original provision of the law when an amendment to that law was declared unconstitutional. In that case, the Otieno case, the court held that at paragraph 46 of that decision, that the inconsistency that the court found to be that the provision, the amendment was unconstitutional, arose from the day that amendment came into force. And therefore, the provision was a nullity from that date and not the judgment date. In short, what the Court of Appeal was finding in that case was to say that the minute that amendment took effect and the court subsequently declared the amendment to be unconstitutional, the unconstitutionality does not arise on the date of the judgment, but on the date the amendment took effect. However, the court also considered the question of what would happen in the intervening period when that amendment was in force. At paragraph 47, the court answered that question, and the court found that the actions that had been taken or uncrystallized when the statute or the amendment was in force were not unconstitutional and could be salvaged and could be held in regard to that. However, most important, in regard to the particular amendment that the court was considering, the court found that once the provision was declared unconstitutional, that provision, that amendment became void from the date of the amendment or the date the amendment took effect. So therefore, we can equally do a comparative analysis. In our submissions, we have referred the court to the position in the South Africa, position in Canada on what happens when a statute has been declared unconstitutional, and I believe the court is going to consider that when it retires. However, I would like to, at this point, to refer the court to a South African Constitutional Court decision in the Vin case, where the court found that once a law has been declared to be inconsistent with the Constitution, that law ceases to have any legal consequences. That is what our own Court of Appeal is saying, that once the amendment was declared to be unconstitutional, it ceases to have any legal effect. And then the question is, therefore, what would happen to the original provision? I think that is the issue that this court would address. So once the amendment falls off, what happens? The IBC in this court has submitted that once the amendment falls off, the original amendment, which was the subject of the amendment, is deleted or ceases or equally to have the full force of the law, meaning there would be a lacuna. There would not be any law that governs that particular provision or that particular area that has been declared unconstitutional. So the question then is, or the issue as I understand it, is not the legal effect of the declaration of invalidity, but the effect of the original provision that was the subject of the amendment. We submit that a declaration of unconstitutionality does not affect the original position of the law. Once the declaration has taken effect that the amendment is unconstitutional, then we revert status quo ante, and for a good reason, to prevent a lacuna being there in law. Therefore, in our humble submission, the provision on quorum remained in force as the governing law until either the declaration that set aside that unconstitutionality, invalidity is set aside, or a new law is enacted. However, we are very well aware that any court that sits down to determine or consider the constitutionality of a law has equal powers or has the power to grant an appropriate remedy as far as that declaration is concerned. The court may and has many other times issued prospective or retrospective application of the declaration. At this point, therefore, I will ask the court to look at the orders that were issued in the Katiba Institute case. In that case, the court issued 2 declarations on constitutional validity. It returned a verdict to say the provisions they were unconstitutional and declared them as such. The court did not move further to save that declaration. The court did not suspend the declaration. Unlike the South African Constitution that provides expressly for the power to grant an order of retrospective application or prospective application of the declaration, the Kenyan Constitution does not directly provide for such a relief. We are, however, aware and we are cautious to the fact that the Kenyan Constitution equally provides for the court to grant an appropriate remedy. We therefore submit that the order of prospective or retrospective application was not granted in the Katiba Institute. Such an order would be available right now to the appellants if it was pleaded in the Katiba case. If, even when it was not pleaded, the court granted the order as an appropriate remedy to suspend the declaration of invalidity. And therefore, because the court in that case did not suspend the retrospective or a prospective application, did not find as such, it therefore means that that order is not available in this case at this time. Because they were not granted in the Katiba Institute, this court is not sitting on review of the Katiba Institute case, neither is it sitting on appeal of that decision. So, therefore, the law today as it is on quorum of the IBC is as set out at paragraph 5 of the second schedule of the IBC Act. Interesting, this provision has not been challenged in these proceedings, has been inconsistent with Article 251 of the Constitution, and therefore we urge the court to find that the second schedule on the second schedule to the IBC Act on paragraph 5 that provides for the quorum of IBC has the full legal effect and serves a legitimate purpose in a democratic society. I will now move on to the second issue, which is on the mandate of the IBC and Article 257(4) of the Constitution. Muhuri will address only one aspect of that issue, and it is on the issue of public participation on enactment of the administrative procedures. In this appeal, the IBC contests whether it has an obligation under Article 257(4) of the Constitution to satisfy itself that the promoters of the popular initiative and conducted public participation on the BBI bill before it certifies that under Article 257(4) and 5 of the Constitution, it had been supported by more than 1 million registered voters. On this issue, we submit that, number one, IBC had an obligation under Article 257(4) and 5 to satisfy itself that the criteria that was established in Article 257(4) and 5 was applicable while using the existing laws and guidelines. At this point, I will refer the court to the question that was asked by the Chief Justice yesterday, when she did ask whether or not it is important to have some form of a legal framework that would guide public participation on the mandate of the IBC and Article 257(4) and 5. We would answer that question, the Chief Justice, and say, at the time the IBC undertook the verification and certification of signatures under Article 257(4), there was no law or any regulations that provided for the actual procedure on how the IBC would do that, including public participation. This finding was made also both by the Court of Appeal and the High Court, and interesting, it has not been challenged in this court. Therefore, in the absence of a regulatory framework, IBC ought to have been guided by the provisions of Article 10 of the Constitution that generally provide for the principle of public participation as a core aspect of governance in this country. The Constitution at Article 257(4) envisages a 3-month window period between which the IBC would undertake its processes under Article 257(4). We of the view that the 3 months period would equally be used by the IBC when undertaking the verification of signatures to grant the public sufficient time to confirm whether or not they had appended their signatures in support of the amendment bill. Such public participation was made to look like it would be so difficult to attain. In our view, we have the view that, as it was in the administrative procedures, that the IBC should provide a process where the public get to confirm indeed to the IBC that if they've appended or they were in support of the bill. They should provide a window period within the 3 months period envisaged in the law for a complaint mechanism, as well as a mechanism to resolve those complaints when they arose. In the instant case, the IBC provided in its administrative procedures that were indeed found unlawful that the public had 22 days through which to verify whether or not they were in support and had provided their signature in support of the bill. However, IBC published the names of those people in its website and provided for 5 days period through which members of the public would indeed confirm to the IBC whether they are in support of the bill or not, and also the 5 days period was also to be a complaint period. The question therefore is, did IBC have a simple, accessible, and transparent processes for signature verification that would enhance public participation in the process as envisaged under Article 257(4) and 5? The answer is no. The process was not simple, how the public would get to participate and verify their signatures, because when you go to the IBC website, and this information is on record, IBC provided a PDF scan. One could not use or search their name or ID number on the website because it was a PDF scan. Even I, as an advocate, we had to spend voluminous time going through the list to indeed look through the list and understand what the IBC was doing. Number two, the IBC put this information on its website. Was that accessible to majority of Kenyans? Satisfactorily not. The website stated that the notice to make complaints would be there for 2 weeks. However, the IBC shortened the period to 5 days. How many Kenyans have access to website and internet in this country? How many are able to go through, have internet, access it, and be able to complain to the IBC that their names are erroneously put or they did not provide their signatures? How many? Very few can. Was it verifiable? Was it accountable? How the IBC undertook this? In the absence of a legal framework, in the absence of lawful guidelines and regulations, even we are clear that it also breached its own administrative procedures, who was the IBC accountable? Can we therefore say that there was public participation in the verification and certification processes as envisaged under Article 257(4) and 5 of the Constitution? The answer would be no. On the second aspect of public participation, the question then would be, how should it look at upon the verification and the certification. On this one, I agree with the submission that was made by Mr. Ngumbo yesterday, that public participation would arise on 3 instances upon the bill being certified as being supported by 1 million registered voters. The first instance would be at the county assemblies. The county assemblies have an obligation under Article 196(1) of the Constitution to undertake public participation in its legislative mandate. So at the point it is considering the bill, of course, it is envisaged that it would use and would avail the bill for public participation. The question would be, was that done? Public participation is a factual issue. It is an issue that ought to be proven through evidence. The county assemblies are parties in this suit. Unfortunately, they did not participate in the proceedings, and therefore, being a factual issue, it is conclusively to say that there was no public participation at the county assemblies in absence of the requisite evidence. The second instance when public participation would be envisaged is at Parliament, when Parliament is considering the amendment in terms of Article 118 of the Constitution. And equally, at the very end of the process, when the IBC is undertaking the referendum, that obligation would be in form of civic education on sensitizing the members of the public on the content of the BBI draft bill or any draft bill. We therefore submit to that end that there is a need for legal framework to guide the processes on public participation with the IBC constitutional mandate and obligation, especially while undertaking its verification, certification, and referendum processes. Such a legal framework is very important because it would make the process accountable to the law and therefore be able to ensure that it complies with the Constitution or any other legal framework. Thirdly, we submit that without a legal framework, there exist so many gaps. And one of that gaps is what the Chief Justice did identify: public participation. How is it supposed to be done? Had we had a legal framework, it would be very easy for us to go back to that legal framework and seek whether or not the IBC complied with the law. Indeed, Chief Justice, there have been attempts made by Parliament to legislate on these processes. On record, you'll find 2 bills that are currently pending through Parliament. A casual reading of the 2 bills would provide that indeed at Section 8 and at Section 4, both of the bills provide for public participation. So there is need for a legal framework. There is need for a legal framework to guide how the IBC undertakes its mandate under Article 257, 4, and 5 of the Constitution. Having said that, and having finished what the 2 issues are, I will therefore urge the court not to disturb the order that was issued by the Court of Appeal, Order number 14, that issued a permanent injunction restraining the IBC from undertaking any of the processes under Article 257(4)(5). That order has not been appealed, and the issue of an existing legal framework has also not been appealed in this court. We therefore urge the court to affirm the Court of Appeal findings and we dismiss the appeals. We also associate ourselves with the submissions made by the third apparent on the issue of quorum in this court. And that will be all from us. Thank you. I will donate the remaining minutes to the 7th and the 8th respondent. Thank you, Chief Justice.
The donation should be to the 11th and 12th?
Yes.
Thank you very much for your submissions. We will now hear from the 11 and 12 respondents.
May I start? Sorry. May I start?
Proceed.
Thank you so much. It's my pleasure to appear before you, my Lady Chief Justice and President of the Supreme Court, and my Lords, my Ladies, Justices of the Supreme Court. My name is Ongoya. I appear together with Mr. Ogada for the 11th and 12th respondents in the appeal. In our 55 minutes, I will endeavor to use 30 minutes and reserve 25 minutes for my colleague, Mr. Ogada, to deal with the remaining issues that we have organized ourselves to deal with. In terms of filings, I would invite you, in addition to considering the petition number 402 that was before the High Court, to also consider the grounds of objection dated 18th October 2021, as well as our written submissions dated 9th of December 2021, and our case digest and bundle of authorities appearing in 3 volumes dated 22nd December 2021. In the interest of time, I will seek to just draw the court's attention to the following matters that I consider fundamental and overarching as you read those voluminous submissions and authorities. First, my lords, my ladies, we will remind each other that we have a history as a country, and that history has taught us some lessons, some of them very fundamental lessons. Fortunately for us, a bulk of the council appearing at this podium, and my lords, my ladies, seeking to make this monumental determination, you have been a part of that history as citizens of this country. And that we should never let down the generations that will follow us by delivering a verdict that may make generations to come to have to live through some of the pains we have lived through as a country. Part of those pains were captured by retired Justice Aaron Gitonga Ringera in the case of Njoya versus the Attorney General, which you have been referred to, and which I'll implore you to read and have inform your verdict. And to call you to consider that history, my ladies, my lords, is not to invite you to engage in extra-legal considerations. Parliament has done the same thing in Section 3 of the Supreme Court Act. It has asked you that at all times you must endeavor to give us an authoritative and impartial interpretation of this Constitution, and in so doing, to develop jurisprudence that respects that history, so that attempts at clawing back on the Constitution that appear innocuous sometimes, you must be hawk-eyed to see them for what they are, particularly if they are dangerous rodents. Because again, we know that a dangerous rodent will chip away bit by bit, but eventually bring down huge infrastructure. So, in terms of the development of the dispute now before you, I would ask my ladies and my lords to remember that before this dispute was determined by the High Court and eventually the Court of Appeal, there were 2 advisory opinions that were sought before this court by the county assemblies of Nandi and Kericho and the county governor of Makueni. My lords, my ladies, in your wisdom, and we respect that, you directed that you will not exercise jurisdiction over those opinions to allow this dispute to go through the formal dispute processing mechanisms from the High Court up to the level it has reached. I say that was wise because this dispute has therefore had a benefit of the contribution of dozens of lawyers and a number of persons not formally schooled in legal training, and it has had the benefit of reasoning by a dozen superior court judges, 5 in the High Court and 7 in the Court of Appeal. Without suggesting that you are bound by the decisions of the High Court or the Court of Appeal, I submit that a product of the minds of a dozen superior court justices is not for dismissal by a wave of the hand. It must be taken seriously, and an element of deference must be given to it, so that any disagreement with it must be after serious soul-searching and serious reflections. So that this court, I submit respectfully, should approach the reasoning of the 5 High Court judges and the 7 Court of Appeal judges with a substantial measure of deference. I submit that it's a sound principle of appellate advocacy and appellate judicial decision-making processes that when we're dealing with a second appeal, as is the case here, it is not appropriate to reintroduce and reopen for consideration concurrent factual findings of the Court of First Instance, in this case the High Court, and the Court of First Appeal, in this case the Court of Appeal. If we take that principle in consideration, we then must dispose of some 2 matters with a measure of ease, my lords, my ladies. As a matter of fact, the High Court looked at the evidence before it relating to public participation in the process now before you. The Court of Appeal, as a court of first appeal, had an obligation, and it re-evaluated the material that was before the High Court and came to its own conclusion, and the conclusion was insufficiency of public participation as a matter of fact. I submit respectfully that it is not open for counsel appearing before you or for this court in its decision-making process to reopen that factual issue as to whether there was, in fact, sufficient public participation. As a matter of fact, the High Court, as a court of first instance, and the Court of Appeal exercising that jurisdiction I've alluded to, re-evaluated the question of who initiated this process. And it came to the conclusion that it was the President of the Republic of Kenya who initiated this process. It is not open for this court to reopen that question of fact. And that, therefore, will dispose of a number of questions that have preoccupied the minds of many counsel who have appeared before you today. Having said that, allow me to come to the specific issue that was introduced in the judicial system by the 11th and the 12th respondents now before you, that's Mr. Juma and Mr. Ogola, which led to the order at paragraph 495A Roman 12 of the lead judgment of Justice Musinga, in the terms that the second schedule to the Constitution of Kenya Amendment Bill, and these words are important, my lords, my ladies, insofar as it purports to predetermine the allocation of proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its functions of constituency delimitation is unconstitutional, with one dissent from Lady Justice C. Charlie. That qualification of what was declared unconstitutional is important, and I emphasize it because of the submissions by my very senior learned colleague, Mr. Karori, the day before yesterday. The court in fact found that the provision of the Constitution relating to the number of constituencies in Kenya is amendable without necessarily taking recourse to the four-tier process that the court identified. What the court had an issue with was the allocation of the proposed additional 70 constituencies and the direction of the IEBC on its function of constituency delimitation. When you retire to interrogate whether the court was right or wrong on this question, I was warned that when we tell you when you retire, a lot of laymen think that you'll have to wait for your retirement age before you return here with a verdict. So I use that word advisedly in the technical sense of it. It's important for my lords, my ladies, to ask yourself this question: how did the court of first instance reach this conclusion, and how did the court of first appeal confirm this conclusion? A good starting point for me is what the judgment of the court of first instance says at paragraph 469. It's important that you reflect on what that judgment says at 469. And that will be so because the court has to answer the question, did that court use the correct methodology to reach this conclusion? Did it use the correct methods of interpretation? The court said, the stable canon of principles of interpretation of the Constitution, which have emerged as outlined above, are dictated by our constitutional text. So the court took into account the reading of the text. Heavy weather has been made on the argument that this court abandoned the text completely and converted itself into a philosophical tribunal. No, the court expressly said that it is taking account of our text. Secondly, the structure of that text. Thirdly, the nature of that text, which the court defines to mean the fact that it is a transformative charter. Next, our history, which both the Constitution at Articles 259 and 10 and statute, the Supreme Court Act, the very act that now directs this court, and binding precedents and the context. The court is telling us that it is taking on board all material parameters required for the interpretation of this Constitution for purposes of reaching that verdict. I submit, respect, my lords, that to depart from that verdict, or to invite you to depart from that verdict, the petitioners before you appealing, at least the first and second appellants, had an obligation to demonstrate to you that any of those parameters was an irrelevant consideration. They have not done that. They had an obligation to show you that there was another relevant consideration that those judges were under an obligation to take into account, which they failed to take into account. They have not done that. That then takes us to paragraph 681 of the judgment of the Court of First Instance, which is the High Court. And if you look at paragraph 681, the court engaged in a detailed analysis of the history of Article 89 of the Constitution, which deals with delimitation of constituency boundaries. And the court set out 6 elements in the second schedule, 6 elements that make that second schedule violative of Article 89 of the Constitution. 6 elements. I'll not read them word for word, but you'll see 6 elements. If you go to paragraph 683 of the judgment, the courts then endeavor to elaborate on each of the 6 elements. I'm submitting, my lords and my ladies, that the High Court, as a court of first instance, used a scientific method of arriving at the conclusion that it arrived at. The jurisprudence, as I know it, is not just enough for you as a court to say, well, on my part, I would have arrived at a different conclusion, and thereby substitute the findings of the High Court with another finding. You would have an obligation to tell us which part of the history as stated by the High Court in those paragraphs is a wrong representation of our history. Not even the appellants have endeavored to point at one. Let me just highlight one example. The court said that a constituency is a unit of resource allocation in this country. The court said so. And the court said, to the extent that a constituency is a unit of resource allocation, the determination of distribution of constituencies has an effect on equity or the skewed nature of distribution of resources. And the court therefore said, to have a scientific and equitable distribution of resources, we must have a scientific distribution of constituencies. The court therefore found that since IEBC in Article 89 is subject to a science of delimitation of boundaries that eventually gives us the placement of constituencies in specific geographical areas, it was not open for us to abandon that and determine constituencies politically, to say it is just a political issue, as my learned colleague, Mr. Karori, has purported to submit before you. Again, I ask the question, which part of that method of arriving at that decision violates Article 259 on the proper principles of interpretation and Section 3 of the statute enabling this court, the Supreme Court Act, that gives this court a scientific formula of reaching scientific jurisprudence, can you possibly fault? I submit there is none that you can possibly fault. So we are told that if you predetermine the allocation of the constituency per county politically, and tell the IEBC, no, your role is now limited to just telling us where this constituency is in Nyamira, where this constituency is in Vihiga, where this constituency is in Samburu, you are hamstringing it from applying the complete methodology set out in Article 89, and to that extent, you are beginning to plant a seed of inequity. You're dealing with a country that has a clear history of inequity. So the court is using the correct formula and saying, no, let the IEBC apply its mandate under Article 89. Use the correct formula, knowing that the IEBC's word in Article 89 is not final. If the IEBC makes an error, there is an avenue available for a disturbed litigant to come to court and seek judicial review under Article 89(10) of the Constitution. The court is saying one of the elements that makes the second schedule unconstitutional is that even that right to come to court and complain by judicial review is taken away. How can we fault the court for such a scientific and principled approach to the resolution of the dispute that was before it. I submit respectfully, my lords, my ladies, that if we apply our minds objectively to the manner in which the High Court reached that verdict and the reasoning that the Court of Appeal engaged in confirming that finding, we will affirm, we reaffirm that finding. We will not disturb it. But more importantly for me, when you retire to have a conversation on this issue, you may also need to ask yourself the question, looking at the material presented before you in terms of the establishment of the task force, the BBI task force, the BBI steering committee, the various reports that they generated, and the publication of this bill, at what stage did the second schedule come into being? That's one question, my lords, my ladies, you will never run away from. Because when you're told there was public participation in even the generation of that schedule, you'll have to answer that question. At what point did the second schedule come in? You will notice that the second schedule was what the High Court judges eventually described as an endeavor to amend the Constitution and fundamentally alter it through stealth, because it's a latecomer in the whole process after the hitherto processes have all been exhausted without anyone telling us. So who was this telling us that Siaya County required this number of constituencies? Who was that among the participating public? To that extent, my lords, my ladies, and so as to invite my learned colleague to engage you in far conceptual matters that are of great impact this litigation, I submit that once you look at that history, once you look at the relevant materials the judges took into consideration, once you consider Kenya's history as captured in various stages of review of our Constitution, at least in the latter years, partly captured in the Njoya decision and partly captured in the commission reports, including the Kregler report that you have been referred to in depth. And once you look at the BBI process itself as it flew, you will come to the inevitable conclusion that to the extent that the second schedule of that bill purported to predetermine the allocation of the proposed constituencies to respective counties and direct the IEBC on how to delimit those constituencies, that was unconstitutional. But there's an important question that one of my lords raised yesterday, and I have to respond to it. When you go to the processing of petition number 402 before the High Court, I want you to investigate the question, what position did the IEBC take on that position? The IEBC, throughout the processing of this dispute up to the time it comes before you, has never contested this position of the 11th and 12th respondents. Never contested that position, that this second schedule is unconstitutional. Number one, I want to look at the appeal that the IEBC filed at the Court of Appeal. They did not challenge this position by the High Court. Number two, I want you to look at the appeal that that was filed on behalf of the IEBC before you. They have not challenged this concurrent finding of law by the High Court and the Court of Appeal. Which brings me to the oral representation by my very good teacher and mentor, Professor Githu Muigai, that the IEBC's position now orally at this podium is that Article 89 of the Constitution does not amount to a basic structure. First, Professor Githu Muigai told us that to him, the word basic structure means entrenched provisions. And he traced those entrenched provisions in Article 255(1). You realize that even if you use that test by Professor Githu Muigai, the independence of the judiciary and the independence of constitutional commissions, which includes the IEBC, would become part of the entrenched provisions. So that applying his own test, Article 89 would become an entrenched position, which he equalizes in terms of effect to a basic structure. And therefore, to the extent that the court at the first instance and at the second instance called it as much, we cannot fault the court for doing that. But more importantly for me, the IEBC must be taken from its word and conduct in the respective courts by its formal findings that it has all along been satisfied by the position taken by the 11th and 12th respondents on the first part, and the position taken by the High Court and the Court of Appeal on the constitutionality of the second schedule of the Constitution. I urge you to dismiss the petition of appeal by the Attorney General. I have reasoned that the Attorney General in this matter was mourning louder than the bereaved, the IEBC, which was the real target of the analysis of Article 89, and we would advise it as much. Allow me at that juncture to invite my colleague, Mr. Ogada, to do duty regarding the other conceptual issues that are relevant to this finding.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, Justices of the Supreme Court, my name is Evan Sogada. As a citizen of Kenya, as an advocate of the High Court, I am here to execute duty on behalf of the 11th and 12th respondents, and I will leave to my primary function as an advocate, and that is to speak the constitutional truth and speak the constitutional truth to power. The Constitution, and any constitution for that matter, in its formative force, varies from country to country and from time to time. The French can possibly claim to have been the French and the monarchies and the military dictatorships and assorted republics. The Germans can claim to have been different people under the Kaiser, under the Weimar Republic, under the Third Reich, and under the Federal Republic. For polyglotted societies such as Kenya, and those riven by religious divisions and bleeding memories of civil strife and war, our Constitution assumes an important function. And this function is that the Constitution serves as a uniting force, the only principle of order that there may be, that there may be no other shared moral or social vision other than that of the Constitution. And it's only the Constitution that unites these eclectic societies that we tried to cobble in what Professor P.L.O. Lumumba calls the Berlinian construct, the nation state. The Constitution as a product of the people being the authoritarian creator, the emendator of the Constitution, bears special significance in Kenya in the 21st century. The solemnity of the occasion today for the Supreme Court cannot be overemphasized. The duty of this court cannot be overemphasized. Former Chief Justice of Malawi, Andrew K.C. Nyirenda, in course number 19 of 2020, says that it is the duty of any court to safeguard the purity of the law and to sanction any evasion, any erosion of violation. That is the duty of the Supreme Court of Kenya. That yours is to ensure that constitutionalism, the rule of law, is maintained and is reified. And what do we mean by constitutionalism? Constitutionalism means that government must be hedged in substantive limits, that there is what is permissible under a constitutional order, even if the perfect majority are against it, even if it upsets majoritarian interests. Alicia Ngoya has spoken about a history, the history of our constitutional journey. The most overlooked part of the Constitution is the preamble. Paragraph 3 of that preamble talks of honoring those who heroically struggled to bring freedom and justice to our land. Justice Muhammad Ibrahim, the victims of the Nyayo Chambers, Nyayo Torture Chambers, Gitobu Imanyara, James Agri Orengo, Maina Kenyati, Baby Pendo, clobbered to death while carried by her mother. These are the matters that we have to remember when you exercise your solemn role in determining this petition. The thrust of the operative legitimacy by the Attorney General and the proponents of the BBI bill is to the effect that the whole exercise was an exercise of amendment. My brother Nelson Harvey and Mutuma referred to you dictionary of definitions for the term amendment. I want to look at the term amendment, Justice Wanjala, from its etymological hasin, the origin of the word. The origin of the word is from the Latin phrase emendere, E-M-E-N-D-E-R-E, which means to correct, to modify a system. An amendment has to operate within a certain parameters of an existing constitution. With regards to boundary delimitation, Article 89(1) identifies 290 units, representative units, and canonizes them as constituencies. Now, these constituencies have been divided within 580,367 square kilometers that geographically is called Kenya. That geographical area enjoys constitutional and international law significance. Under Article 5 of the Constitution of Kenya, the territory is protected. Under Article 2.4 of the UN Charter, that territory is protected. Professor Wanjala, Justice Wanjala, under the principle of uti possidetis juris, international law, we are bound by customary international law to respect those boundaries as bequeathed to us at independence. The Attorney General has two offices within his department: the Kenya International Boundaries Office and the Treaty Division. At independence, when the colonialist was departing, there are certain instruments that were granted to us that clearly behove us to respect this territory. Where am I going with this story? That when the Attorney General, through my learned senior, Mr. Karori, tell us that they are going to create constituencies, that the people can create constituencies outside these parameters, the 580,000 or so square kilometers. The question is this: where is this territory outside 580,000 square kilometers that we are going to create these new constituencies from? Are we going to create them in the air? Are we going to create them below ground? Are we going to create them in the sea? Reductio ad absurdum. It doesn't make sense. The upshot of our argument is this: that any creation of new constituencies can only happen within the demarcated 580,000 square kilometers. And that's where the IEBC comes in. Its role in Article 88 and 89 is to conduct an exercise in delimitation. The Attorney General, through Mr. Karori, waxed lyrical in the defense of the impugned bill, stating that the 70 constituencies were aimed at ensuring fairness and that the allocation of the 70 constituencies was a political role. I shuddered when I heard of the term fairness. The question that the Attorney General must answer before this court is, who determined what is fair? What are these parameters of fairness? And implicit in that argument is the majoritarian representations of the schedules to the BBI bill represents fairness. If we can take it for face value, Nairobi has 12 intended constituencies under the BBI bill. What are you telling my brother from Samburu, Leisagor, Naisula from Samburu? What are you telling Muikali from Machakos? That fairness is synonymous with numbers? Hell no. The Constitution of 2010 has departed from majoritarian premises. And we are saying that we have to be egalitarian. We have to cater for the minority. It is pro those who have been marginalized. And that is the statement of the Constitution 2010. Let us look at the manner in which this bill was originated. It was the position of Senior Counsel Kirago that the origin is hazy. The question is, from their own admission, if this origin was hazy, where did the people come in to prescribe the exact number, that is 70 constituencies? Was the poor peasant, the woman in the village in Yimbo Usenge, consulted in terms of whether she wants a constituency? The people of North Hor constituency, it takes you 5 hours from one corner to another. Embakasi, Babu Owino's constituency, to the Uri's constituency, it takes about 10 minutes. Fairness. What are we talking about when we talk about fairness? What are the impugned provisions of this bill? I would want to refer the Honorable Court to Section 10 and Section 74 of the BBI bill. What do these impugned provisions do? Number one, they purport to create 70 constituencies. 2, they direct the IEBC to determine boundaries and to delimit 70 created constituencies to specific counties, leaving out others. They stipulate the time period within which the IEBC must act. They stipulate to the IEBC the criteria to be used. Sacrilege, heresy. The IEBC is an independent constitution, enjoying functional independence. And the Supreme Court has addressed itself time and again on the question of independence. I refer this court to the decision of matter of interim Independent Electoral Commission, advisory number 2 of 2011. I also refer this court to the Communications Commission of Kenya and 5 others versus Royal Media, 2014 EKLR. The court spoke of independence, and I'll refer you to exactly what this court said. You cannot depart from that. For purposes of rule of law and for certainty, I beseech you to maintain the statement on constitutional commission independence. There was a position held here by Mr. Karori on behalf of the Attorney General that we are still in the conceptual mooring of 3 branches of government. May I correct that assertion loudly and clearly in the presence of my teacher sitting on the other side, Professor Ben Murumbi Sihanya, that we have since moved from the traditional understanding of government as 3 branches. We have moved from the trias politica model, and with the commissions, the independent commissions coming in, that is argued, amongst others by Professor Sihanya, that we have a 4th arm of government, so that when Justice, the Deputy Chief Justice, and the Chief Justice represent the Supreme Court at the Judicial Service Commission as commissioners, their presence there is in an independent office, contradistinguished from the judiciary, where they sit as judges of the Supreme Court. Power contrary to contra-power, ambition contra ambition. That is the Montesquieu edict in terms of separation of powers. So that when the IEBC is a beneficiary of separated power, its functional capacity under Article 88 and 89 must be respected, and without apologies. What is the mischief that was intended by the Constitution in terms of demarcation and delimitation? There are certain undergirding principles that were intended to be safeguarded. And these principles we have highlighted, and I refer the courts to Volume 3 of our Case Digest, from page 450 onwards. There's a scholarly article by a lady, Lisa Handley, giving a history of boundary delimitation from a comparative perspective. The history has been looked at by the High Court. The principles: impartiality, equality, representativeness, non-discrimination, transparency. I will address myself to the question of impartiality, because that is what concerns us with the IEBC. The process of boundary delimitation is removed from the political organs, and the IEBC should shepherd the whole process and guide the people in terms of the whole process. Alicia Ngoye has gone through that process. I will not go through it. But if the people were to be aggrieved by the processes conducted by the IEBC in creating new constituencies, then we have a recourse to Article 89(10). What this bill, in its purport, tries to do is to short-circuit the Constitution, to remove the ability of the people to seek redress from the judiciary. The manner in which they propose for this new creation of constituencies to come in is what we call in conceptual theory constitutional octroi. What is constitutional octroi? An imposition, a patrimonial way of creating a constitution. Contra a thesis to what we have under the Constitution 2010. Ours is a liberal democratic manner in which we generated our constitution. And it is important to know that the people, in terms of creating these new constituencies, must influence the role, must have an influensive role through public participation. Public participation is important for this reason, that conceptually, we are trying to take away imposition by politicians, and the people must qualitatively and quantitatively have an influence with regards to decisions that affect them. Constitutional octroi, as being suggested by the Attorney General, is a seeping, an insidious threat to constitutionalism. That should it be allowed, and bearing in mind our history, our constitutional history, we will be inviting the insidious tarantula effect, whereby politicians can creep in and massacre, butcher, murder the Constitution as we know it. It must be resisted. The judiciary as a negative legislator. A question was posed here in terms of the judicial role. The judiciary is a negative legislator, so that when the courts correct misgivings or errors in accordance to the Constitution, the judiciary becomes a negative legislator. It is a proper function for a Kelsenian court. So that this court is besought not to be afraid to dabble into what will otherwise be termed political. Because I heard the term political being bandied around here. This court should take safeguard and safety in the Indian case of the state of Rajasthan and others versus Union of India, 1977, where the Supreme Court of India, Bhagwati Jay, said that the constitution is a matter of politics. So that Justice Ibrahim, when you deal with the constitutional question, this is an essentially political question. You cannot be intimidated into handling it as if politics is the preserve of politicians who think cyclically in terms of 5 years and think about their partisan interests. You, as lawyers, are trained to think in terms of posterity, in terms of our life, our collective life as a country. You, as of necessity, must deal with the question. In conclusion, Chief Justice, in 1803, on a cold, frigid morning of February the 10th, 45-year-old Justice John Marshall and his colleagues in the American Supreme Court, dealing with the question of appointment of magistrates through commissions, made a tectonic statement. It is inherently the province of the judicial branch to state what the law is. The tectonic effect of Madison versus Marbury, which was decided on this day, reverberated all over the world. And the province of judicial review, as we know it, owes its life to this momentous day. The Supreme Court sits on the crest of such a moment. You are being requested to make an intellectually sound and bold decision. We know that you're equal to the task. The country is looking up to you as the Supreme Court. And this court owes the country a duty to do what is right. Equality, justice must prevail. The rule of law. Justice Ouko, that poor child in Maralal will expect you to make a definitive statement that when he or she appears for a public job interview, he or she will not be sacrificed for the reasons of her ethnicity or for the reasons that her father or mother has a small name. In your quest to find judicial truth, we pray that this court remains alive to the history, our history motleyed by corruption, nepotism, malgovernance. The court is besotted to remember our constitutional history and the price that was paid by martyrs who along the way shed blood, the seed of our constitutionalism. Writ large, our national sanity, our joie de vivre has been replenished and remains alive due to a bold judiciary. And every time this court has made bold decisions, our esprit de corps as a country is always reflected. We are happy because from the gloom and misery that we have been subjected by politicians, the courts have displayed sparks of life. And this court will have the occasion to do it again. Please do it again. Do not be afraid. And Justice Patrick Omwenga Kiage, Lord Justice of the Supreme Court, of the Court of Appeal, says that the judge under the Constitution 2010 is a lion or a lioness. You are expected to roar the constitutional truth. You are expected to say it like it is. I have recourse in conclusion to a very noble son of Africa, whose text I carry in my hand, and that is Justice Digeng Moseneke, retired Chief Justice of Deputy Chief Justice of this South African Constitutional Court, Professor, University of Pretoria, who says in his book, All Rise, a Judicial Memoir, at page 305 thus: fidelity to our oath of office is important, not because we are important, but without it, it is not us, but our people who will suffer. By our people, I mean the full diversity, poor and rich, white and black, female and male, urban and rural, the marginalized and powerful. All deserve our unwavering protection, which our Constitution demands us to provide. After all, you are the ultimate guardians of our Constitution, for and on behalf of our people. That maxim, that edict by Justice Patrick Omwenga Kiage, the judge under the Constitution 2010, is a lion or lioness. Go ye forth and roar. Roar. Let every corner of this country hear the roar from this court. We submit that all the appeals as standard be dismissed in their totality. Thank you.
Thank you very much, Counsel, for the submissions. We will now hear submissions by the last respondent, Kituo Sasheria 79 respondent.
My humble apologies, Your Ladyship. The 4 minutes will be donated to Kituo Sasheria.
Honorable Chief Justice, Dr. Camino is taking a health break. I think he'll be here in the next 1 minute.
We can take ours. In that case, then, as we wait for Dr. Camino, we will also take a break up to 11.
Live from the Supreme Court and also here in studio. And the judges have taken a break after two counsels there have made their submissions. We had Elisha Agoya and also Evans Ogada. And now, before we have that, the judges coming back for the second session, we have constitutional lawyer and advocate of the High Court, Henry Kurauka, to help us break down some of the things that we have heard without even going to the particulars of the case as it is ongoing. Counsel, karibu sana.
Thank you very much.
Yes, first things first.
Thank you.
First things first, we are having very, very brilliant minds there. The lawyers, young, and actually they know what they are saying.
True, and congratulations to our young lawyers. I know most of them, they have done us proud. and their future is bright. They have really submitted very well, and they know their work. They have analyzed various issues arising from these petitions. Good.
And trying to make things easier and more digestible to any Kenyan, what are some of the possible outcomes? Because this is the apex court. We are not saying that the decision at the High Court and the Court of Appeal, we can go to another court. This is the apex court.
Yes, any appeal has three possible outcomes. The first outcome is dismissal of the appeal, in which case the judgment of the Supreme Court carries the day. The second option, or rather a possible outcome, is to allow the appeal wholly, or rather to grant the appellants all the prayers they are seeking. The third and most probable outcome is partial success, and some issues may be, accommodated by the apex court. The appellants may succeed on a number of issues. For example, the judgment that was rendered by the Court of Appeal, there were some changes from the High Court judgment. The judgment, or rather the orders that were impugned by the president, were granted, and therefore the president was sanitized in that judgment of the Court of Appeal. So we also expect the Supreme Court to make its decision by agreeing with the other courts, or disagreeing only, or agreeing on some parts or on some orders, and maybe giving fresh directions.
And can fewer Supreme Court judges overturn the decision? We had 5 judges of the High Court, then we went to 7 of the Court of Appeal.
Yes, this is a question that keeps on arising from the layman's perspective, or from rather the logic.
Yes.
Many people may wonder how 5 judges of the High Court, 7 judges of the Court of Appeal, that makes 12 judges who have already delivered a judgment in favor of the anti-BBI team. So many people are wondering how a quorum of 5 judges in the apex court, that is our Supreme Court, will overturn the judgment of all the other judges. But legally, and in our court system, the decision of the higher court carries the day, irrespective of the number of judges. In other words, even if there are only 5 judges in the Supreme Court hearing this matter, their judgment carries the day. But again, the numerical number that is there creates certain perceptions, the public perception, not necessarily the legal reality. The jurisprudential value of more judges is higher than fewer judges. And it's on that point that you realize the president of the Court of Appeal constituted 7 judges, so that the 5 judges from the judgment of the 5 judges of the High Court could be either overturned or upheld by the Court of Appeal, and to improve that jurisprudential value of the judgment. However, the Supreme Court has so many judges. The number is pegged in our Constitution. Unless a retiring Chief Justice who is less than 70 years opts to serve in the bench, that's when we can have an expanded team of 8 judges who would, counter the number of the 7 judges in the Court of Appeal. But the law, the court system, the Constitution is very clear. The 5 judges' decisions in the apex court carries the day. Therefore, they can actually overturn the judgment, the findings of all the other judges. And therefore, all the issues that are impugned may be decided in finality by the Supreme Court. Therefore, we expect the Supreme Judge either wacheze kama wao ama wasicheze kama wao.
Okay.
Thank you.
Indeed. And the question that is in every Kenyan's mind, because all the legal jargons and big words flying in court, is BBI salvageable as we are? We know we cannot go to a referendum because we are just 7 months away from the general polls. Is it salvageable?
As we speak, it is not possible to salvage it before the elections. Remember, it is already very clear and affirmed in our Constitution and by IEBC that come August 9th, we shall be electing our new leaders. The journey to have a constitutional reform is quite a lengthy process. It takes time. It takes several months. In my view, it takes more than 1 year, because you have to start with, the proposals. First, you start by choosing the route to pick, whether the parliamentary route or the popular initiative. Whichever route we pick, then there must be whereby we have the promoters to come up with the questions, with the areas that are proposed to be changed. Secondly, we go to the next level, whereby there is public participation. Very important. After public participation, the views of all Kenyans and the stakeholders must be incorporated in the draft document that should now go to the Constituent College, or what we call the referendum. Without following that proper procedure and without involving public participation, because the sovereignty of this country, the sovereignty of everything is the people of Kenya. And therefore the Constitution is supreme law so far as the people have already given it that supremacy. Because otherwise there will be so many people coming with all manner of attacks on the document that does not follow that path, and they may allege that the Constitution has either been dismembered or mutilated.
And the procedure of amending the Constitution is quite complex, and we saw almost all the counties, even the senators and MPs, they were in agreement that we should amend the Constitution. Also, the numbers were there. But looking at the High Court decision and the Court of Appeal decision, and even starting with the High Court decision, it seems that the BBI proponents skipped a lot of things that they were supposed to do before then. Even the question of the BBI referendum bill came up at the High Court. Why is it that they didn't look at all these things that they were supposed to do, the groundwork, laying the groundwork for a referendum? Because the 5 judges of the High Court and the Court of Appeal literally tore into the BBI.
Yes, because the procedure is as important as the product itself. Therefore, if there is any procedural technicalities or challenges that were not resolved and aligned to the law that we have, then the final product will have issues. Now, one thing that we should realize is that no party is attacking the BBI document wholly. They're only attacking a few sections that appear to conflict with the Constitution. And the Constitution is very clear that any law that is inconsistent with it shall be null and void. Therefore, the procedure is very, very critical. And you find the BBI bill, particularly Section 10 and 74, they seem to create some provisions that are outrightly unconstitutional. In other words, like creation of more constituencies,
Yes.
that is a preserve of the IEBC. Therefore, that was unconstitutional, among many other areas that were challenged. My view is that the BBI process, and a lot of hurdles, there were a lot of challenges, has been canvassed. However, the document is good. It can be, improved. It can go through, and it can help many Kenyans. There is the question of basic structure. It is a doctrine that has been adopted world over, that there are certain provisions in the Constitution that cannot be amended, because that would be mutilating the very Constitution that we are supposed to safeguard. However, the people themselves have the power to amend the Constitution. And that is why the 4 critical stages must be followed, starting, of course, with the proponents, the proposals, the civic education, collation of, the views of various people, the constituent colleges, the referendum, and so on. Unless that route is followed, the final document will face the same hurdles. I want also to inform our listeners that even the power of citizens, we citizens, cannot overdo certain things. For example, if today we passed a constitution that promotes infringement of certain fundamental rights, for example, right to life, or to human treatment, or degrading treatment, the right against degrading and inhuman treatment. Even if all the Kenyans vote for such amendment, the High Court has powers through a petition to annul such sections.
Okay, and talking of some of the issues that have been brought about in the appeal, and also I believe this was a contradiction, because even the court observed that they talked about the president also being a Kenyan. So in other words, he can initiate the BBI process, because the High Court and the Court of Appeal ruled that the president was the initiator, and talked about, according to Article 257, he cannot do that. And they're talking about presidential immunity. Then how can you tell us the president is also an ordinary Kenyan, yet you are seeking presidential immunity? Is that a contradiction in law?
Yes, without going to the merits or demerits of the appeal, because the law does not allow us to do so, I would outrightly say that immunity is provided under our laws. For example, our judges enjoy absolute immunity for their decisions or actions in performance of their duties or omission done honestly and without malice. The same extends to our president or someone exercising the powers of the presidency. So that is a settled law, and I think the Supreme Court will have to give their verdict on that. Now, there are the other aspects that have raised a lot of anxiety, a lot of conversation, a lot of submissions on the issue of basic structure. The government is the structure of government itself. Okay, are we pro-presidential system, or are we having, parliamentary system, or are we having combination of the two systems? So that is a basic point that needs serious conversation. Therefore, there appear to be 50-50 views, rather people,
meaning the Supreme Court judges.
They are not the Supreme Court, but even in the legal fraternity, we appear to have different opinion on the doctrine of basic structure.
And looking at the BBI, can we have, if the project is not quite dead, as even the court has observed. It just didn't follow the law. Can we have a hybrid system of amending the Constitution where we take some things that can be amended to Parliament, Article 255, and the others which have to go to the referendum, instead of packing them up just as the BBI proponents had done? Is that salvageable?
Yes, it is possible. The Constitution is very clear that Parliament can, on its own motion, do amendments in certain provisions, not everything. The Constitution has created a self-amendment procedure that must be followed. The point of contention is that we adopted the popular initiative, and there is evidence that has featured very prominently that the government financed the whole process. The committee allowances that Madam CJ was raising. The constitution of the members to those committees, the advertisement of the committees that did all that work. So there appear to be some evidence that discredit the popular initiative, because the intention in this case is to avoid a situation whereby the president may use constitutional reforms to entrench either himself or herself, or to amend the law to favor the prevailing government. Like, for example, Parliament cannot come up with a law extending their life in Parliament, lifespan. Okay? That would be unconstitutional. So the mischief, the intention, the purpose of that procedure is to avoid any abuse of power that may be, abused by people in power and who have resources and who may use public resources to spearhead the process.
And without even going to the merits and the demerits of the case, the Attorney General has been accused there of mourning louder than the bereaved, that is the IEBC. And IEBC, whichever decision the court takes, could there be, and on the issue of quorum, could there be petitions coming in court because of the decision that the Apex Court has made? Because talking of quorum, IEBC has done by-elections. IEBC has also undertaken the first phase of the voter registration. Can it affect any decision or mandate that the IEBC did during this time that they're talking about there was no quorum?
Yes.
Or it is specifically quorum of quorum when they were verifying the signatures?
If the High Court judgment was allowed to stand, we may be in a constitutional crisis. There have been so many by-elections. A lot of contracts have been signed by IEBC. A lot of, activities have been carried by IEBC. Therefore, if it is ruled by the Apex Court that there was no quorum and they were not entitled to do all that, then it follows, just the way night follows the day, that all what they have done in the absence of quorum is null and void. But again, there are other challenges. For instance, if an MP was elected on a by-election conducted by IEBC that didn't have quorum, then by the time you go to court, already the time frame for petitioning has already passed. On the other hand, the MP was elected, or leaders who were elected then have already taken office, and their oath has already been taken and they are working. So to undo what has been done may be impractical and may create more difficulties and may be tantamount to absurdity.
And since 2017, after the Supreme Court overturned the presidential result and ordered for fresh, and now the BBI, the quality of jurisprudence that we have in the country, compared to, because actually our constitution, we have borrowed heavily from other constitutions. What can you say about the quality of jurisprudence that we have in the country?
Oh, yes.
Because a lot of countries are watching us.
I do a lot of public interest cases.
Yes.
Some of them affecting the government and other institutions. But what I can say is that I do not have any quarrel or difficulties to state that we have some of the best judges, if not in Africa, in the world. We have very intelligent judges, very committed judges, very analytical, and very judicious judges. If you look at our High Court, it has very good judges. In the High Court, the same, in the Court of Appeal, the same, and also in the Supreme Court. There is this perception, I must state, that our Honorable Chief Justice Martha Koome is pro-system, or rather pro-executive. But I just want to warn anybody who may find himself or herself on the wrong side of the law. I know CJ Martha Koome, even if you are her father, she will never bend the law to favor you. That is the truth. And I want to assure Kenyans that Martha Koome is a very judicious lady, very fair, very honest, very impartial. And if the law is against you, you are in for it. If the law is for you, pro you, you are safe. All the other judges of the Supreme Court are very good judges, impartial judges, very sharp, very committed, very analytical, you know. And all of them, even some of the younger judges, like Justice Lenaula, very smart, grasp of facts and everything, very smart, and all the other judges. So, in my view is, let Kenyans not speculate. Let us give the Supreme Court an opportunity to give a judgment, and today they are going to give us a judgment date. And let Kenyans accept the verdict by those judges. There have been a lot of, you know, complaints that, you know, some of the judgments appear to contradict their previous findings. But again, the Constitution is very clear. All the judgments and decisions of the Supreme Court are binding on the other courts, but not itself. Because they can do a judgment today, and tomorrow they can depart from their previous decision or other views, and that is allowed under the law. But we hope our Supreme Court will create a consistent precedent, a consistent, you know, prediction, so that when you have a matter that is going before the Supreme Court, you are able to advise your client and to predict the outcome of every matter. Thank you.
Indeed. And looking at the AG, he was the first person to file an appeal at the Apex Court regarding the BBI. And somebody may argue, the Attorney General, you are the chief legal advisor of government. But looking at the High Court decision and the Court of Appeal, there's a lot that was supposed to do. There's a lot of foundation, a lot of groundwork that was supposed to be done. How comes the AG wasn't able to give a sober advice so that all these legal hurdles that the BBI faced could have been foreseen even before the first petition at the High Court?
Ben, the truth of the matter is that government is a very complex creature. There are so many parties involved and institutions. There are so many interested parties. You have hand of the system, okay? You have hand of the deep state,
yes,
the politicians, and so on. My view is this. One, the Honorable Attorney General is actually overwhelmed. Today, I found his team in so many cases in various courts across the country. There are very few petitions where the AG is not involved. There is a lot of drafting. There are many things that requires advice. The mega transactions, before they are paid, the AG's opinion is necessary. We have so many public institutions. They always seek an advisory opinion from the Honorable Attorney General. Yet, there is so much for him to do. Now, coming back to BBI, constitutional making process is a political process. If it is a political process, then it means politicians are the drivers of the process.
Yes.
And if politicians are the drivers of the process, watacheza like politicians. And you see, politics do not have structural process like the law. There are a lot of issues that arise when people are playing politics. So a lot of challenges, a lot of loopholes, a lot of missteps, a lot of, oversights will come in the process of achieving a process, because the politicians will look at the end result that will make them have an upper hand against any opponent and so on. So if you look at the BBI process, of course, the politicians spearheaded the process, and even the opponents of the BBI were also politicians.
Okay, hold the thought. We are also keeping tabs with one of the events that is taking place today, actually in the next couple of minutes. Today being Thursday, the 20th of January, His Excellency President Uhuru Kenyatta will be presiding over the parade for direct entry inspectorate course at the Kiganjo Police Training College main campus. Actually, as you can see, those are live pictures from that event, and we also have our reporter Timothy Kipnusu, who will be updating us on what will be happening there. And the president is yet to start the event, but any moment now, we see the dignitaries are already seated, and some of the invited guests, that is from Kiganjo. That event is supposed to be starting at about 11, and we will be crossing over there for that live event to be presided over by the head of state beginning 11 a.m. And in case you just joined us, we are keeping a keen eye also on the happenings at the Supreme Court, where it's day 3 and the last day of the BBI appeal. After that, the judges will retire to make a determination on that, so that we may know what is the way forward for the BBI. And that, because we will be crossing over to Kiganjo, what next for the BBI? Can they dismantle some of the things that they have been told by the court that they didn't observe, like the BBI bill that was pending in Parliament even before the signatures, were being collected, over 4 million signatures, but they were having a pending bill, a referendum bill at Parliament. That's some of the observations that the court did observe. Can they now start from scratch and observe the law and return this? And how long could that take?
Now, because they elected to pursue the legal process,
yes,
they had obligation to pursue that process to the very last point, and that is the Supreme Court. So that was perfectly in order. The next move will depend on the decision rendered by the Supreme Court judges once they retire to write their judgment. So their findings will be binding to all the parties. And finally, if the Supreme Court makes recommendations, those recommendations must be followed, the whole process has to be followed, the procedures to be followed, and guided by the judgment that will be delivered. If the appeal is dismissed, then the Court of Appeal judgment carries the day.
Indeed. And thank you so much, Henrik Rauka. As you can see on your screen, the judges are back in session. Let's now cross over to the Supreme Court for the case to continue.
79, the respondent to submit.
May it please the May it please the Honorable Court, I do apologize that when this matter was called this morning, I was not here at all.
It's okay, Dr. Kaminwa.
Thank you very much.
We understand.
Yes. My Lady Chief Justice, it's a very great honor and privilege for me to appear before you this morning. This is my first time to appear before you since you are elevated to the high office of the Chief Justice. My lady, we have known you for many years, and we know what you stand for. We are happy that you are now sitting on that great chair as the Chief Justice of the Republic of Kenya. And may I point out also respectfully that your deputy is the Honorable Lady Justice Mwilu. Lady Justice Mwilu, we remain proud of you. We remain very much having high regard of you for the courage and the boldness and the difficulties that you have gone through. But you have stood firm, and you will go down in history as a great woman. My Lady Chief Justice, may I say something to you that in our history as a country, there was a lady called Wangua wa Makeri. Wangua wa Makeri was a very courageous woman. She rose to a position, or a political position, within the Kikuyu community. And the men feared that she treated them very badly. To such an extent that the men took an oath and said to themselves that never again shall they be ruled by a woman. My Lady Chief Justice, we still have some people within our own society, particularly men chauvinists, who seem to think that you may turn out to be like a Wangua or Makeri. They fear that you may probably not be someone who will listen to them. But we who have known you for a long time, we know that there's no way you can become Wangua or Makeri. You will treat men and women gradually. The Honorable Lady Chief Justice, yourself and your deputy, you join Club of Great Women of Kenya. You join women like Mora of Kisii, who fought the colonialists very energetically. Lately, the two of you join great women like Professor Wangari Maathai, whom I had the privilege to appear for in court to represent her in many cases, a very bold woman who was tortured, but she stood firm, and she deserved to get the rank of, to get the prize of a Nobel Prize as the first African woman in this country. My Lady Chief Justice, I would like to mention one or two people who have not been mentioned at all. I think that it's appropriate that we should mention our first Chief Attorney General, the Honorable Charles Njonjo. He had his own shortcomings, but it's not appropriate for us, according to the African custom, to emphasize the shortcomings that he had at all. But he was our first Attorney General, and he was Attorney General for about 21 years. But one thing that he stood for, and which we shall remain grateful to him as a community and as a country, in that he was able to preserve and stand for the sovereignty of our country. At that time, the country was going through a very difficult time. We had coups all over Africa. We had people who are wanted to secede from the Republic of Kenya and go elsewhere. Some of our neighboring countries were making claims to our borders and so on. But he stood firm and he was able to protect the executive, to advise the executive, and we were able to preserve the sovereignty of the country. We must remain grateful to him. I would also like to mention two other people. I mentioned Zamba Kitonga, who was one of the first chairman of the Constitutional Review, a great Kenyan of impeccable character and integrity, but it's unfortunate that he is no longer with us at all. I would also like to mention Professor Yash Gai, a very great son of Kenya. He is the one who has developed constitutional and public jurisprudence in this country, perhaps more than anybody else. We stand grateful to him. He is still alive. I haven't been able to meet him for a long time, but I'm told that he's in Kenya. He is living in Nairobi with his lovely wife, Professor Cottrell. Now, if you may permit me to come to why we are here this morning. My lady, I will repeat what I said on my opening words before the Court of Appeal. I will repeat to you, as a country, we have been extremely unfortunate in that we have had a poor crop of politicians. The first crop of politicians that we had in the country measured very favorably with world leaders, with world politicians like Gandhi, like Kwame Nkrumah, like Nehru, and others. That was Mzee Jomo Kenyatta and his colleagues in the first government, people who fought for independence. They had grand ideals for this country. But then thereafter, after their demise, we have now current politicians, and there's very little really to admire them for. Recently I said in Court of Appeal that most of them you get the impression that they are job seekers, they are office seekers. And they come up with things like amendment of the Constitution because they want to continue to be in power. They don't seem to have really much that they can offer the country. Now, I would like to emphasize one thing, my Lady Chief Justice. To look after a country, you must have a creative mind. That is very important. You must have a creative mind where you are able to come up with ideas that can be able to rule the country. And whenever you have a poor politician who runs short of ideas, the immediate thing that he will tell you is that let us amend the Constitution. And that is what precisely happened with the first Constitution. It was amended many, many times, to such an extent that it ceased to be a Constitution. It was not better than a toilet paper at all. We were not proud of it at all. And some of the problems we have at the moment is because of the frivolous amendments of that Constitution that was now overthrown by the 2010 Constitution. Now, there has been a lot of talk about basic structures. I do not wish to dwell very much to go into what has already been said by my very able learned friend. And at this stage, probably I should mention my able learned friend, Mr. Harvey. I thought he did a very good job. He opened the case very well, and he exhibited the impression that he's a person who's very well read and has read the brief very well. I do not wish then to go into a lot of details at all. And I may point out at this stage, my Lady Chief Justice, that should I try to repeat myself, I would have no objection if you tell me that, Hamino, we have already heard that, move on to something else. Now, I will refer you to the Constitution of Kenya straight away, may I refer you to the preamble. The preamble of the Constitution of Kenya is very important when you are considering the question of basic structures. Acknowledging the supremacy of the Almighty God of all creations. My lady, may I pause there? That first sentence, acknowledging the supremacy of the Almighty God of all creation. My lady, it shows that there is something above the Constitution, written Constitution of Kenya. It brings in the concept of natural law. And if any amendment or any proposed amendment is against the supremacy of the Constitution, the supremacy of the Almighty God, that amendment must be struck out. It's a higher law more than the Constitution or the other written words that we find in the Constitution. Honoring those who heroically struggle to bring freedom and justice to our land. Again, that reminds us very emphatically that we should not forget the history that this country went through at all. Dirty and rotten history of assassinations, people having to fly from this country, of the Nyayo era. And at this stage, I may probably my lady, Chief Justice, I've got the book here. A sad book. We lived to tell the Nyayo story. I am almost crying. These were people who were tortured, who slept in cells with water. Some of them thereafter died immediately. They were not fortunate to live as long as Khamin was living at all. They could probably have lived much longer. We have them here. It shows the history of Kenya. My lady, we should never forget the history of this country. And I'm afraid to say, my lady, we still have elements within our society, within the Kenyan society. If you do not stand firm and strong, they would like to take us back to those days of the Nyayo era. We had people leading the country, great minds. My contemporary at the Lions Just School, Nganga Tiongo, living in America. He cannot live in this country at all. Alamin Mazrui, living in America. He cannot live in this country at all. In brief, I'm making a point to you that the Constitution that we have at the moment was deliberately made unamendable. Was deliberately made unamendable. And I refer you in this case to the book called Constitutional Amendments, Constitutional Amendment by Rosnai. I refer you to page 258 of that book. Page 258 of that book. It mentions Kenya, and it says Articles 255 to 257, different procedures for different provisions. The heading is that these are provisions that are, although they are provided for in the Constitution, but they do not have the force of law at all because they cannot be properly interpreted by the courts at all. So I'm taking the position, my Lady Chief Justice, that the Kenyan Constitution, if you read it very carefully, the entire Constitution, it seems to have been drafted in such a manner that, strictly speaking, this Constitution is not amendable at all. The idea being that if you allow people to amend it, that we shall, within a short time, not have a constitution at all. Now, if I may now take you over you to take the court to the preamble again. Proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation. My Lady Chief Justice, that is where one of our problems we have. That's one of the problems we have as our country. And I refer you to a little book that I have. The book, the title of it is Making Constitutions in Deeply Divided Societies. Making Constitutions in Deeply Divided Societies, by a lady called Hannah Lana. Making Constitutions in Deeply Divided Societies, by a lady called Hannah. And I will read only, with your permission, I read only 2 words, or 3 sentences. Nearly 190 national constitutions are in force today. More than half of them have been written or rewritten in the past 3 decades. Many of these constitutions begin with some versions of the famous 4 words, "We the people." Now, my Lady Chief Justice, we the people, are we really a cohesive society? We are tribes. Our political parties are tribal political parties. They share jobs in advance. Jobs are given according to what tribe you are. Whether it should be that, it should be that, and so on. We are already tribes. So we have a problem. We cannot speak of a society or a community that is cohesive at all. We are very far from that. And we are only kept together as a nation by the 2010 Constitution. Amended some sections, parts of that Constitution. The inevitable result will be chaos in the streets of Nairobi, chaos in the streets of Mombasa, chaos in our provinces. We need to nurse it. We need to nurse our Constitution so that we give it opportunity to be fully implemented and to grow. In other words, my lady, what you have to do when you are making any decision, you must exercise restraint. You cannot just go out and allow politicians to say they want to amend this Constitution at all. First, to make it was a big job, was a very difficult job. Now, it's better that we keep it as it is. There are some individuals, for instance, who have come up with a bill. They suggest that we should have a president and deputy president, and then prime minister, and several other positions. These are intended to create jobs for people whom you can actually call tribal leaders in the country. And the small tribes will be discriminated against. The majority will discriminate small tribes of the country. Let us not buy the idea when they tell us that we shall have a more stable society, a more cohesive society, if we implement we implement the bill by giving jobs to certain individuals. We shall be entrenching tribalism, ethnicity in our society. where you have only certain communities that have been given certain jobs or certain positions in the looking after the country. Permit me to go further. There's a respect for environment, which is a good idea, and there's a committed to nurturing and protecting the well-being of the individual, the family, communities, and the nation, which we stand for. Recognizing the aspirations of Kenyans for a government based on the essential values of human dignity, equality, freedom, democracy, and so on. And then exercising our sovereign and inalienable right to determine the form of governance and so on. The point is that this preamble is actually like the ideology that the country stands for. In interpreting Kesavananda case in India, their lordships, the judges, relied on the preamble to the Indian Constitution. The preamble to our Constitution is very important. We cannot afford to ignore it. And in this regard, may I refer you to the authority that supports this submission that I'm making to you. I cannot find the book very quickly, but I have a book that has been written by one of the authors in which he is emphasizing that the preamble can be relied upon in interpreting the Constitution. I may Yes, I found it, man. Hidden itself. I'm referring into a book called Interpreting Constitution, a Comparative Study. Interpreting Constitution, a Comparative Study, edited by Jeffrey Goldsworth. Interpreting Constitutions, a Comparative Study, edited by Jeffrey Goldsworth. And it says this at page 247. The court, that is the Indian court, the court has used the preamble of the Constitution as a basis for articulating the basic structures of the Constitution. That is a preamble. The preamble, the court has used the preamble of the Constitution as a basis for articulating the basic structure of the Constitution. And may I refer to the same book before I lose it again, at page 265. And with your permission, let me read it to the Honorable Court. Despite its shortcomings, that's the Indian Supreme Court, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities. May I pause there? There are some individuals in the streets of Nairobi who may say, why should the judges have such power? Why should the Supreme Court have such power? Why should the Court of Appeal have such power? Why should the High Court have such power? Because they are not elected members of society. But the learned author is telling us this, that the power to amend, the power to guard and look after the Constitution in India is no longer with the elected members. It is no longer with elected members. May I again read this provision very shortly. Despite its shortcoming, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities, such as President. President of India is not elected, the Honorable Chief Justice. The Election Commission, the National Human Rights Commission, and the judiciary. So the point I wish to emphasize to you is that you do not have to be shy to make decisions at all. The fact that you are not elected people is neither here nor there. You are a powerful institution that should protect our 2010 Constitution. It goes on, the Supreme Court, as the apex court with the power of judicial review over all other authorities, has shouldered the heaviest burden. Its assumption of power to review constitutional amendments, which our law also provides for. You can review the constitutional amendments, has made the most powerful court in the world. My Lady Chief Justice, we want this Supreme Court to be the most powerful court in the world, to be the most powerful court in East Africa, to be the most powerful court in Africa. May I again continue? Has shouldered the heaviest burden. Its assumption of power to review constitutional amendments has made it the most powerful court in the world. It has evolved from a timid positivist court into a very activist one. Its more prominent policy-making role has stemmed from its expansive interpretations of fundamental rights and directive principles, and its liberalization of procedural rules governing access to justice. Through its development of that role, the court has earned widespread legitimacy, which has helped to ensure that its decisions have been generally obeyed. My Lady Chief Justice, now that you are sitting on that chair of power, we are asking you respectfully that you give interpretations to the law, to give it interpretation to the Constitution, so that this case or this Constitution or this court becomes the most powerful court in this country and outside this country. My Lady, I've just been reminded by my junior, Valentine Khaminwa, that I've only 7 minutes to go. May I say with respect, I know that you have been giving people 15 minutes or 10 minutes or so on, but if I may say with tremendous respect, I usually think that I have a creative mind, and I can say quite a bit, not for selfish reasons, but I can say quite a bit that can help in shaping the jurisprudence of the country. I ask you very respectfully that you extend my time, that you do not give me only 15 minutes or 20 minutes to address you at all. You give me a little bit longer than that. I think that I can make a contribution to the jurisprudence of this country. My Lady, you remember I talked about the sad history of this country. May I make a reference to 2 books only? I would refer you to a book called Kenya, A History Since Independence by Charles Hornsby. Kenya, A History Since Independence by Charles Hornsby. Charles Hornsby, my lady, has got a Doctor of Philosophy in Kenyan politics. And in his book, he sets out the serious shortcomings that the society, the country has had. I will refer you also to another book, which is written by Daniel Branch, Kenya, Between Hope and Despair. The title tells you a lot. Between Hope and Despair, between 1963 and 2020. No wonder that our former president, Kibaki, a very learned president, when he was being sworn in, he said that he was inheriting a sin that had caused misrule for a number of years in the country. I will also refer you to Article 2 of the Constitution, supremacy of this Constitution. Supremacy of this Constitution. It's my humble submission that just from these 4 words, supremacy of this Constitution, one can state that the basic principle applies in Kenya. Supremacy of this Constitution. What that means that anything that is in conflict with the supremacy of the Constitution must be declared void, null and void. And it's significant, my Lady Chief Justice, that Article 2.5, the general principles of international law shall form part of the law of Kenya. International law also limits the power to amend. My Lady Chief Justice, I refer you to Article 5, Territory of Kenya. I was reading the submission of our very able Solicitor General that he gave to this court. And according to him, the basic structure doctrine does not apply. I have known the Solicitor General for a long time. As a bar, I had the privilege of arguing case against one another, and I found him to be a very able lawyer. But this time I must say to him that when he says that the basic principle does not apply in Kenya, he is saying so with his tongue in the cheek. He is not being sincere. He is not being honest. My Lady Chief Justice, if I may remind you, we have problems with the maritime boundaries down at the coast. And the Kenyan authorities, on advice of the Solicitor General and on advice of the Attorney General, told the ICJ, the International Court of Justice, that this matter cannot be adjudicated upon at all. They were right. I supported them. And you know, they were relying on the basic principle which is contained in this court, in this Constitution. And Article 5 says, Kenya consists of the territory and territorial waters comprising Kenya on the effective date, and any additional territory and territorial waters as defined by an Act of Parliament. This is an issue that any court cannot sit and make a determination upon at all. And they were right. It is a basic principle that the Solicitor General advanced to the ICJ or advanced to the lawyers that let us not go to ICJ. We shall be wasting our time because this is a matter that cannot be litigated upon at all. May I refer you again, very respectfully, to Article 143, protection from legal proceedings. That is the President. Protection from legal proceedings by the from legal proceedings. This with respect to President. Article 143, Article 2. Civil proceedings shall not be instituted in any court against the President or the person performing the functions of that office during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. It is my humble submission, my lords, that if the President is not acting within the law and is not acting within the Constitution, it is actionable. He will be doing so at traverse the Constitution.
Dr. Camino, how much more time do you need? Your time is up, and we have a lot more work to do. Could we give you another 10 minutes, please?
Oh, 10 minutes. Okay, I'm most grateful.
10 minutes?
I'm most grateful. 10 minutes, I'll finish.
Yes.
My lady, I'll finish. Yeah. And then, my lady, I refer you to Article 259, which deals with the construing this Constitution. Particularly Article 3, which says, 259.3, every provision of this code shall be construed according to the doctrine of interpretation and so on. That's so much I can do. My lady, may I draw the court to this provision, the Article 38. Article 38 of the ICJ. Article 38 of the ICJ. According to this article, Article 38, my lady, provides, Article 38 of the ICJ provides for the sources of international law, and it is my humble submission that the sources of international law include decisions made by national courts. And the national courts in this particular principle of basic structure have held in Asia, in Africa, and in America that the basic principle applies. Basic principle is therefore no longer debatable, is a source of international law, and it can be enforced by virtue of Article 38 of the ICJ. I'm quoting this from Brownlee's Principles of Public International Law. I would refer you to a book called The Changing Structure of International Law by Professor Friedman, Professor of International Law at Columbia University. And in his book, at page 153 to page 159, he refers to international constitutional law. International constitutional law. International constitutional law, my lady, involves cases like the basic fractures, the Casablanca case. Regarding the misrule, I'm relying on the book authority called Democracy by Condoleezza Rice, which is to be found at page 216 to 217, where he emphasizes, or where he sets out what former President Kibaki said when he was being sworn in. We have filed authorities for Kituo cha Sheria. We have filed written submissions. We rely on the legal authorities. We rely on the submissions that we have filed. And I invite you very respectfully that you uphold the decision of the Court of Appeal. You uphold the decision of the High Court, and you hold that basic principles apply, and the President does not enjoy immunity at all. With those remarks, I say to you, thank you very much. I'm sorry I've had little time. I would have liked to talk more, but out of respect for the court, I should obey what the court says. Thank you.
Thank you very much, Dr. Camino. We also celebrate you and honor you for the work you have done in the profession. You have mentored many lawyers, and you have really defended the Constitution and the rule of law all your years. And for us, you remain our symbol of unity in the legal profession. So thank you very much. We appreciate you also. So this time now, I will ask my colleagues to seek clarification from the submissions so far made by the third appellant and all the respondents who are opposing the first and second appeal. Judge Ouko.
Thank you, Judge President. Thank you, Counsel. I've got a couple of questions, some clarifications. I'll start with Mr. Harvey. Once again, on basic principle, basic structure. Would you say that the holdings of both the High Court and the Court of Appeal give sufficient guidance to the citizens of this country on how to go about this? Does it tell them what provisions are secured, which provisions will not offend the basic structure? Because looking at the decision by the High Court, it seems that from the preamble to all the 18 chapters, including the 6 schedules, are no-go zones. The Court of Appeal affirming them, but with a bit of modification, seem to say that the entire Constitution actually says the Constitution itself and all that it contains. Same court seems to suggest that yes, there is basic structure, but it's codified or enacted in 255(1). And that for you to touch it, you must go through some 4 sequential steps. But these steps are not spelled out by the court. So the question is, have we guided as a judiciary, as courts, the citizenry sufficiently to know how to go about this in future? The second one is related to the 4 sequential steps. What is the basis of this? Is it part of the procedure contained in Article 255(1) to 11? Is that can we find it there, these 4 sequential steps, or is it something we picked from somewhere else? That will be it for Mr. Harvey. My next question is to Ms. Kituku for Muhuri. The attention of the High Court, and I believe that of the Court of Appeal, was drawn to the fact that there are certain actions that had been taken by IEBC by the time they were being told that they were not properly constituted. For instance, there were 30 by-elections that had taken place, and I dare add that even the election of the President of the Court of Appeal was done during this period. What is the status in law of these actions that were taken when you said the commission was not properly constituted? My lady, that's all from me.
My first question goes to Mr. Murare Omoke, as well as I think Ms. Angawa and perhaps Ms. Kituku, who talked about the quorum and the issue of minimum and maximum membership in the commission. In the Constitution, there are express provisions for quorum, for Parliament, for the impeachment of the President, for the Supreme Court, and when you come to the chapter on the counties, the legislation for counties must provide for quorum. Then there are other institutions or agencies like Cabinet, like the commissions, where they prescribe a minimum and a maximum. This is different from quorum. You seem to suggest that quorum ought to be read in to the Constitution, whether or not there is legislation. My question then would be, for what purpose then has the Constitution stipulated a minimum and a maximum? What is the purpose of putting in a minimum or a maximum? What do those words mean? My second question goes to Mr. Ongoya. You know that this matter has come to us as an appeal as of right. And I wasn't sure that, it seems to me that you're suggesting that where there is a question of constitutional interpretation, which is pegged on the actions of a state agency or body, then we, on second appeal, would be bound by the rule of factual limitation on a constitutional question, constitutional interpretation. I just wanted you to clarify that. Finally, to Ms. Kituku, you've suggested that the IEBC, the public participation was not enough, the use of the website. What would you be suggesting could be a method that the IEBC could use in order to reach the Kenyans who you say were not reached? Secondly, I wasn't clear. You talked about evidence that there is no participation in county assemblies. Then you said that the county assemblies have not participated in this case. I was hoping that you could perhaps point to us on record the evidence that shows that there was no participation at the county assemblies, just to clear up the point you're trying to make. Thank you.
I think I can follow that up by seeking clarification also from Ms. Kituku on the question of public participation. And we all recognize that there was no legal framework to guide the process of public participation. My question is, in the absence of this legal framework, does the Constitution allow some broad parameters that can be used for public participation? And if so, what are they, and how can they be measured? The other one is also a follow-up, maybe to Dr. Kaminwa, and this is about the basic structure. I'm happy you are now calling it the principle, because I've been wondering in my mind, when does a doctrine become a doctrine of general usage under the common law or under the international law? But now you say even judgments from the Commonwealth can be elevated to the same level as the international law that is applicable in Kenya as per Article 2(5). Those principles are jus cogens, known as jus cogens. I'm wondering, at what stage does a judgment of the court get elevated to that status? What does it go through to be elevated to that status of a principle of general application under the international law? And I'm looking at the case of Kesavananda, which was before our constitution, and wondering whether it had actually informed our constitution because of the preamble, the Article 2, and the Articles 255 to 257 and other articles on human rights. That would be my clarification on that. Judge Wajara.
Thank you, Council, for your submissions, which will go a long way in aiding us to arrive at a reasoned judgment. I seek clarification from Mr. Harvey. Yesterday you consistently appeared to draw distinction between amendment of the Constitution and alteration of the Constitution. And then you did state that when it came to the Constitution of 2010, the word alteration disappeared. Did it just disappear? Or could it have been the intention of the framers of the Constitution? And why do you think it disappeared? And if it did disappear, independent of the thinking of the framers, how would this court resuscitate it in a constitutionally interpretative manner? Then all of us, I think, have been told about the four sequential steps which would then legitimize any intended amendment to the Constitution. And I think, Mr. Harvey, you can again weigh in on this one. The idea of constituent power, where and how do you locate the juridical form of such constituent power? And then finally from me, I go back to ETOPS. Let's get back to ETOPS. I have a feeling it could become a doctrine in future also. So this is then Ms. Angawa and maybe Ms. Kituku. Let us, for purposes of argument, say that Parliament, in conformity with the minimum of the composition of IBC of 3, that Parliament, for the sake of argument, enacts a law to give effect to that minimum, and indeed sets the composition of IBC at 3, and goes ahead to set a quorum of either 2 or 3 on the basis of that minimum, would that be bad law? That's all from me.
Thank you very much, Mr. Lesinko. If I heard you correctly, you said that the Indian Constitution protects eternity clauses from amendment. Where is that law that says so? What are these eternity clauses? Because if you look at Article 368 of the Indian Constitution, Parliament can amend any article of the Constitution, including 368 itself. But there's a procedure set out in 368. Interestingly, in fact, in India, no court can attempt to challenge, can attempt to overturn any amendment by the legislature, including the state legislature. So where do you get this? What are these eternity clauses that you're speaking about that are not amendable? Where do you get that from? Mr. Harvey, in follow-up to the questions by my two colleagues, at paragraph 1289 of Kesavananda, the judges are saying the history of India and learning from experiences of other countries, have endeavored to make their constitution as precise and as detailed as possible so that one need not depend upon judicial interpretation to make it survive. Correspondingly, they are made it flexible so that there is need for amendment can be done. In that context, looking at Article 255, and I borrow this question from Senior Counsel James Orengo. If indeed Article 255 does not contain clauses that would not require amendment, and that under 255 you can actually amend all the clauses, what other clauses, what other matters, because 255.1 refers to matters, and I'm asking myself the question, under 255, it says if the amendment relates to any of the following matters, then those matters must be taken to a referendum under 255 or 256. Now, what are the matters outside the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, national values, Bill of Rights, term of office of the President, independence of the judiciary and commissions, functions of Parliament, devolution, and in fact, the provisions of Article 255. What other matters would you foresee as not requiring an amendment through a referendum, to which you must then defer to the primary and constituent power? What sort of matters are we thinking through? So that, because it's not enough to say, let the courts decide. We must understand as judges, as we sit here today, there are certain matters that you're saying are reserved for us. What matters are those in your thinking? Mr. Dasa and Ms. Kituku, the questions have been asked by my colleagues about Article 250 sub Article 1. But I want to reiterate the question by putting it this way. No provision in a constitution like ours is placed in vain. So that I think in answering my colleagues' questions, tell us as a constitutional question, what is the purpose for 250 sub Article 1? I had arguments that IEBC can do some matters administratively. IEBC can do some matters as a matter of constitutional mandate. Now, explain to me what it can do under 250 sub Article 1 with the minimum of 3. Thank you, Chief Justice.
Thank you. I think we'll follow the practice of giving you 3 minutes to respond.
My Lady the Chief Justice, I have 3 questions. They cannot humanly be answered in 3 minutes. I'll suggest I answer them effectively because they are important to this clarification. My Lord Justice Ouko, you've asked, did the High Court or the Court of Appeal provide with exactitude the location of the basic structure doctrine? The answer is yes. And both the High Court and the Court of Appeal said, for you to identify the basic structure, you must look at the history beneath that particular article. Over and above the history, examine the text. Take, for instance, the judiciary. How did it migrate from the judicature to the judiciary? Because before the judiciary, the judicature was a department of the executive. To that extent, therefore, for you to locate the basic structure, you must confine yourself to those 2 fundamental guiding points. I will give you an example. Nelson Harvey here is male, is a human being. He was born whole. To use the Bible verse in Genesis 1, and God looked at him and said, behold, a perfect being. I can lose a limb. I'll be given an artificial limb to make myself better. I can lose my sight, I'll be given glasses to make my sight better. But if you dismember me negatively by separating the limbs, the lower limbs and the torso, I will die. And if I'm to be succeeded, then I'll have to be replaced by somebody else, perhaps Nelson Harvey II. Essentially, that is the best and simplistic understanding of the basic structure. You will not give me a pig's heart to make me whole. I will live for 1 month and die. So I think to that extent that question is satisfactorily answered. Now, the 4 sequential steps, are they located in the Constitution? No, they are not located in the Constitution. Why are they not located in the Constitution? Let me use myself as the example. I was born, I will die. The manner of my death is not known. Perhaps I will die in my sleep. Perhaps, and to use Professor Githu's words, I will be assassinated, because in my status I cannot be murdered, I can only be assassinated. Perhaps I'll die of ailment. So you cannot define with exactitude the manner in which the Constitution will end. Therefore, if you see all these constitutions, the 2010, I believe, I'm not being asked to stop. The 2010, the 1969, and the 1963, they do not provide for the manner of end. But when you look at the 2010 Constitution, you will see it repealing the 1969 Constitution. Those 4 sequential steps, you will trace them from the writings of Professor Nubweze. I can categorize them as primordial, as the imperial creation. You cannot find them within the body. Let me give you another example from the Bible. Trace the genealogy of Jesus in the book of Matthew, Luke, or Mark. You will see it sequentially taken back to Joseph, to David, and finally to Abram and Adam. Beyond Adam, it is the Creator which is outside the being. And it is these basic concepts that must be read into the basic structure, doctrine, etc. And if there is a contradiction that may be introduced into this argument, let's go back to the being. There are 2 principles. One, we came into existence by creation. We'll follow the genealogy up to Adam. The other one, we came here by evolution. Whichever avenue you pursue, you must go back behind the being. And that is what we call the primordial power, insofar as the constituent power is concerned. Now, constitutions are peculiar to France and the United States of America. These are the 2 countries that said will henceforth not be governed by an emperor or the King of England, but will formulate a way in which we'll govern ourselves. We'll set up a constitution with 3 fundamental organs: the executive, the judiciary, and the legislature, so that these functions will not be left to a monarch. Dr. Smokin Wanjala, you've asked, how did the word alter disappear? Was it deliberate? And what do we do about it? It is my answer that the disappearance of the word alter was premeditated and deliberate. And if you look at the writings of Professor Nobweze, he says the fundamental changes to the Independence Constitution were permissible because of a flaw in the definition of the word alter. So that flaw has now been corrected, so that you will not graft an antelope on me and you say you have a being. That is the intention of the framers of the Constitution. And the court ought not to resuscitate it. Because if you do resuscitate it, you will have created the mode of death of a constitution. And that is not what the framers of the Constitution intended. We've gone back to tracing the origin of the constituent power. Does it have a juridical form? The Pharisees asked Jesus, when will we know the end of time? We will never know the end of time, but you will see the signs of the end of time. That is what the teacher said. Now, Aaron Ringera has given clarity to this matter in the case of Njoya versus the Attorney General at page 677. This is what he said. Indeed, it is not expressly textualized by the Constitution. And, of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela. For instance, I was born here in Kenya. I need not to have an ID or passport, to use the terms of Miguna, for me to be a Kenyan. The ID and passport is there for formality, and it is from that premise that we must perceive the constituent power. Justice Lenaola, you've referred to the Kesavananda case, and you've asked us to create a clarity of where these other facets of the basic structure reside outside 255(1)A to J. Now, that is the reason as to why they have to be basic. When we were in Musingu, Ongoya went to study power mechanics, and because I didn't have greater qualification when I joined high school, I studied art and design. But there is a dichotomy between a diesel engine and a petrol engine. There is the carburetor and the injector pump. And if you doubt this difference, if you attempt to kick it like a stone, you will not travel. It is as simple as that. Now, what is the foundation of a democratic state? The foundation of a democratic state is based upon the social contract, with the trichotomy of parliament, judiciary, and the executive. And if any of those two are fused, then you are obliterating and obscuring that dichotomy. And I can say affirmatively, from my limited learning of the law, that the basic structure must of necessity include the executive, the judiciary, the legislature, and the Bill of Rights. Because for the Englishmen, they said, oh, King, no, you cannot rule us like this. We must have the Magna Carta for us to have terms of engagement. For the French and for the American, they said, we must have a written constitution. And for that, the king will not be the legislative. The king will not be the judiciary. And will have rights, rights that you are not giving us, rights that inhere in us as being. To that extent, therefore, those must be entrenched and respected as the basic structure, which can be discerned outside 255 1A to J. I believe I've done my part, or if there's a follow-up question.
Yes, you took your time, 9 minutes.
The time is not of essence here. This is a serious enterprise.
Yes.
The Supreme Court only sits once after 5 years. You did that in an election petition. What is the hurry? Where are we going to?
Yes, thank you.
Good morning, my lady the Chief Justice, my lady the Deputy Chief Justice, my lady and my lords, Justices of the Supreme Court. Your Lordship, Your Ladyship, Justice of the Supreme Court, Njoki Ndung'u, you have asked, there are express provisions on quorum for Parliament to conduct business for this court to sit. That's at Article 121 and Article 163(2). There is no express provision for quorum of the IEBC and indeed the other independent commissions that are established under Chapter 18, for the basic reason that the Constitution provides for the Commission's minimum and maximum composition. It does not provide a specific number of composition under the Constitution as it does for this court, which is 7, and it does for Parliament and for Senate, because those are specified in the Constitution. Hence, the ability for the drafters of the Constitution to set the quorum as they intended during the drafting. Now, what is the purpose of the minimum and maximum? And I think that is related to the question that has been asked by His Lordship, Dr. Wanjala, and His Lordship, Justice Isaac Lenola. The engine, the two engines that I spoke about, the Constitution and the statute. The Constitution did not specifically provide for the set number of commissioners. It therefore could not provide for the set number in terms of quorum. That is why the Constitution, under 88(5), says that the Commission must operate on the basis of the Constitution and the legislation. And in the legislation, Parliament, in its wisdom, sets the composition as it did, currently at 7. And set the quorum in the schedule at paragraph 5, whose deletion or repeal or declaration of unconstitutionality is core to the dispute before this court. And I will clarify for my lady, Njoki Ndungu, Justice of the Supreme Court, that it was not my suggestion, at least not to my recollection, that we need to read quorum into the Constitution. That seems to be the implied suggestion from the submissions of the IEBC, that we should read the minimum of 3 as the implied quorum for the Commission.
We will give you another 3 minutes, but please don't rehearse. We have what you said in the submissions. Just stick to answering the question.
Thank you, my lady. That was the IEBC's submission. Our submission is that you cannot imply quorum based on Article 251, which provides for a minimum of 3. His Lordship, Dr. Wanjala, asked if Parliament, in its wisdom, sets the composition as 3, which is the minimum provided for by the Constitution, and sets quorum at 2, I disagree that it could set quorum at 3 because that would be a unanimous decision, and quorum is the minimum number required to make a binding decision. Would that be bad law? If Parliament, in its wisdom, did that, went through the legislative process, gave an opportunity for public participation, had the views, and did that, and no one challenged that constitution of 3 in a court of law, and there is no decision of the court that finds it to be unconstitutional, then it would stand as good law. But as we speak, the section that provides for the constitution of the Commission has not been changed. So quorum cannot be a minority of that set composition. And I would like to end there and bring to this court the current situation. If you were to take the submissions of the IEBC and confirm or put it as the position in law that the quorum can be 3 because the composition can be 3 as set as a minimum in the Constitution, what you will be saying is that the Commission, as currently composed by statute, would be bound by a decision of the minimum membership. But what is most important, my ladies and my lords, is that alongside the declaration of unconstitutionality of paragraph 5 of the schedule was a declaration of unconstitutionality of paragraph 7 of the schedule, which said that where a unanimous decision is not reached, then the decision of the majority of the members present and sitting would hold as a decision of the commission. As it is now, therefore, there is a lacuna, if you were to take the arguments of the commission, in the law on that question, so that we are going to a point where 3 commissioners will say our decision can bind the commission, whereas on the other hand, 4 commissioners would say we are the majority, our decision ought to bind the commission. That is the risk that we are at, because the flight went so far away from the flight path with 1 engine and passengers inside it. Do not forget that. I urge this court not to forget that. We will have that situation, and I do not think it is in the realm of imagination, where 3 commissioners will say, we stand, and 4 say, we stand. Thank you.
The Honorable, the Chief Justice, my ladies, my lords, my name is Justice Njiru Nyaga, 3rd appellant. And for the sake of clarity, Justice is my name, not my title. I will be addressing the questions that have been raised by the Honorable Judges, starting with the question of Lenaola J as to the purpose of Article 250, sub-article 1, concerning the minimum of 3. Can IEBC do some matters administratively? And the simple answer to that is no. And we wish to seek solace from the decision of the High Court in this matter, where they were explicit that the statute which has been implemented by, has been enacted pursuant to Article 88(5), does not make a distinction between administrative and policy issues. And that is a point of departure from the decision of Biwott, where the Biwott case was saying it is policy issues only. But the High Court distinguished that, and they said that is bad law, and they respectfully departed from that. So our straight answer to that is no. As per the law, they cannot even do administrative issues. To the question by Lady Justice Njoki, what is the purpose of Article 251? In essence, it just defines the composition, the minimum number of members who can compose an independent commission, because it is trite that there is safety in a multitude of councillors. And when you look at the Biwott case, the issue of quorum came up, and it was clearly defined that quorum is the minimum number that is required for a commissioner, for a commission to transact its business. So 251 states the minimum membership, but the legislation that has been enacted, that is the 2nd schedule to the IEBC Act, clearly provides for the minimum number of commissioners to transact business, and that is 5. And we still hold that the High Court and the Court of Appeal were right in finding that that provision is still valid. Let me go quickly to the next question, and we will be pleading with the Honorable Chief Justice that for Topua's question, he can be granted his time to address it, the question on basic structure that has been raised by Honorable Lenaola J, Judge of the Supreme Court. To the question of Justice Smokin Wanjala, if membership is set at 3, and I will be requesting for just a few more minutes so that I also address Oko's, Justice Oko's question. May I proceed? Thank you. Concerning the question by Justice Smokin Wanjala, if membership is set at 3 and the quorum at 3 or is set at 3 or 2. Is that bad law? We respectfully submit that that will be bad law, having in mind the important functions that the IEBC conducts. And when you look at the letter and the spirit of the Constitution, it will be wrong to have important decisions of great magnitude being transacted by only 2 commissioners. So for that, we will humbly respectfully submit that that will be bad law. Concerning the last question by Honorable Justice Ouko, what is the status of the actions that were taken when the IEBC was not queried? We respectfully submit first that what is before this court is not the matters that were taken by IEBC, such as even the composition of the court, or the by-elections. But what is before this honorable court is a question of the amendment of the Constitution. However, that being said, we take solace in the decision of this honorable court in the case of Mary Wamboi Munene versus Peter Gishuki Kingara and 2 others, a 2014 decision, where you are very clear as to the effect of a provision of a statute being declared unconstitutional. It can either be retrospective or prospective. Therefore, in this case, for matters which the court will look at and see that this, if we are to apply them retrospectively, they might have serious implications, the court can respectfully decide to have them be prospective. And therefore, we humbly submit that you do not buy into the suggestion that has been given by the Honorable, the former Attorney General, Professor Muigai, who I greatly respect, that in any such case, the default position ought to be the application is retrospective. And that is what the decision, that was your decision in the case of Mary Wamboi. And allow me just to finish with what Justice Kriegler said. And this is what he mentioned. I'll read quickly in that decision, which this court rightly quoted. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado. Though it's sometimes convenient to have the court to declare it to be so, and every proceeding which is founded on it is also bad and incurably bad. You cannot put something on it and expect it to stay. It will collapse. The default position concerning this matter is that the declaration of an unconstitutional amendment to a statute should be retrospective. And for that reason, paragraph 5 and paragraph 7 of the IEBC Act, second schedule, still apply.
Thank you. Thank you. Don't rehearse. Yes, we have taken the answer. Ms. Kituku.
I will invite now Mr. Topua.
Thank you, Chief Justice. I will start with the question asked by the Honorable Justice Ouko on what would happen to the actions that have already been undertaken by the IBC when it was not queried. To answer that question, I would suggest and say that the powers of a court to issue a remedy upon a declaration are very varied. A court can suspend the applicability of the unconstitutional invalidity either retrospectively or prospectively. When it does apply it retrospective, it saves those acts that have already been done. when it applies it prospectively, it does cure the gap that would happen between the date of the declaration and the date that Parliament would be ordinarily remedy the invalidity. Therefore, in this case, we would suggest on the first aspect to say, number one, that either we apply it retrospectively or prospectively. The actions on Article 257.4.5 were done after the judgment in the Katiba Institute. So it will not have any effect on this, it will not change the status of that declaration. However, if there was no order that was issued suspending the declaration, a party that is aggrieved by that, if no order of suspension is issued, it means that the declaration, although issued in rem, cannot apply to each and every action that IBC did. A party aggrieved by a particular action that IBC did during that period it was not queried must move the court in order to have that declaration applied in that action that that party is aggrieved with. For example, if a party was aggrieved on the results of the elections of the president of the Court of Appeal, that party must move the court and have that declaration apply in that case. So I refer the court to maybe the example in the Murwatetu case, when this court issued a declaration that the death penalty was unconstitutional. It did not mean that every convict who was on the death law was set free. However, that the lower court or any other judge who sought to apply that reasoning in the Murwatetu case had to bring it within the confines of the case that was before them. So it does not entirely apply bracketry, but it has to be brought within the ambit. My lady Chief Justice, I think I'll be seeking more time. I have 5 more questions to answer for the members of the bench.
Yes, if you can summarize them to answers, please don't rehearse your submission because we have it. Just zero in on the answer.
Thank you, Madam Chief Justice.
So we are giving you another 3 minutes.
On the issue of public participation, as was asked by the Chief Justice and Honorable Justice Njoki Ndung'u, I will start by saying public participation is a factual issue. It can only be determined by evidence, whether or not there was public participation. The issue was specifically pleaded in the Third Way Alliance case that there was no public participation. None of the parties in the matter brought any evidence to prove whether there was public participation. In the absence of such evidence, then the court did find that there was no public participation. Although the counties had been sued and processed the bill without public participation, did not participate in the proceedings. So therefore, the obvious conclusion would be, in the absence of any evidence, there was no public participation. The issue of public participation was actually not contested. The IBC did not provide any evidence on the issue that was raised by public participation in the pleadings, in the Superior Court. On the question by the Chief Justice, how should this public participation look like? Ideally, it would be left to the IBC to determine how best to undertake public participation in line with the law and the regulations that exist. Its own procedures, administrative procedures, provided how IBC would undertake public participation in relation to verification and certification, in relation to signatures and Article 257 form. There are many methods that IBC could have done that. At a minimum, it ought to have perhaps provided the list of the supporters to the popular initiative at every polling station for inspection, so that members can have an opportunity to engage with the list. Number 2, it could have also used other media services that are easily available to the members of the public. It could have used print media, all television, the radio station, TV, just to popularize that list. And also it could have done what the Elections Act says, that's what I've said, through physical inspection of the register. On the question again by Justice Njoki Ndung'u, Justice Wanjala, and Justice Lena Ola, on the quorum, on why Article 251 and its importance, I will start by saying that we can't find that answer in the CKLC report. The CKLC on the Constitution, there were concerns that sometimes the commissions could have been too big or they could have been too small. So the idea was to restrict the number of the commissioners. And number two, Chief Justice, I humbly request for 1 minute to wind up. Thank you. To restrict the number or provide Parliament with the leeway to set the appropriate number of members as commissions are different and carry out different constitutional obligations. For example, the Kenya National Human Rights Commission has 5 members set by registration. The National Gender and Equality Commission has 5. The Judicial Service Commission has 11 members. So this is an issue that was left to the Parliament to determine the number of commissioners. So therefore, in Parliament, in its wisdom, which Parliament does not legislate in a vacuum, but Parliament understands and knows the needs of its people, understands its history. When it did set the number of the IBC commissioners as a minimum of 5 and a maximum of 7, it clearly undertook its mandate and understood what it was doing. So that registration that put the number as 5 has not been challenged in this court. It is not on appeal, and we urge the court to find as such. I will associate myself with the submissions made by Mr. Nyaga on the issue of business and policy of the IBC. Thank you.
Thank you, my lady, my lords. Direct the questions. Am I suggesting that this court is bound by the rule of limiting itself to matters of law in case of a second appeal? Yes, that's what I'm submitting, for the following reasons. Article 163 that gives that right of direct appeal, it's a direct of appeal where what is at issue is interpretation or application of the Constitution. In doing that, you employ Article 259 of the Constitution, which provides legal principles. Section 3 of the Act establishing this court, which sets out legal principles. So the matters that you are doing are actually application of legal principles to the question at hand, and not an investigation of the facts afresh. Secondly, the case of Munya, which you engaged with this question a little, you found that a second appeal in an election matter can be preferred to this court because it involves an interpretation and application of the Constitution, but that is limited to questions of law. So I wish I had more time to do further research, but bottom line is, based on that, I'm convinced that we are limited by that rule. Just a brief engagement with the question of the quorum, because I have a bit of time there. It's important to understand the scheme of Article 251. Minimum 3, maximum 9. It's not arbitrary, it's not magical. Parliament cannot just pick 3. It has to engage with the many other factors you find in Article 232 of the Constitution, Article 10 on regional balancing, on gender balancing. So if it just arbitrarily picked a number, then that number can be challenged because of the rule of harmonious reading of the Constitution. Fortunately for us, Parliament in the IEBC case did not pick 3. So to that extent, again, the question of the IEBC must be determined in full light of the numbers that Parliament in fact picked and the statutory arrangements that there were regarding the question of the quorum of the IEBC. My assistant, Mr. Ogada, desires to make some contribution, my Lady Chief Justice. I'll kindly invite you to, I'll request you to allow him to make a measure of contribution to one of the questions that we thought could have been dealt with better.
We'll give him 3 minutes.
Fair enough.
Thank you, Your Ladyship. The question of public participation, your question was precise. In the absence of legal framework, does the Constitution provide for how to deal with public participation. Article 259, Your Ladyship, Chief Justice, 259.1, conceptually that's purposive interpretation. 259.3, a non-living tree reading of the Constitution, originally from the case of Edward versus Sankey, Canadian case. Read that together with Article 165.3, which gives original primacy to the High Court, sitting as the Constitutional Court, to interpret the law. What am I saying? The court, the judiciary, has the unique role to give meaning to the abstract provisions of the Constitution, such that when Justice Odunga sits and in expert Egekuru says that these are the parameters, these are the conceptual contours of public participation, the court has exercised its mandate under the Constitution. Quickly, on the question of when does Commonwealth law and international law become part, for purposes of persuasion, our law. Article 2.5 speaks of general rules of international law. Conceptually, that is wrong. It should be general principles of international law. Justice Dr. Wanjala, you have taught international law before. You will bear me witness. Article 38.1, where we get the sources of international law, speaks of general principles of international law. So as a subsidiary source of international law, we will look at the preponderance of decisions from around the world. And when these courts identify certain principles, certain doctrines to be applied robustly or uniformly around the world, then you will be persuaded that humanity has found these principles to apply commonly, and we will adopt them. That's my submission. Thank you.
You have the floor, Dr. Camilo.
Yeah, can I speak, my lady? Yeah, thank you. My lady, I have understood your question, but with respect, we are dealing with a specific case, Casavananda case. And it's my humble submission that this case, Casavananda, is taken care of by Article 38 of the Statute of the International Court of Justice, Statute of International Court of Justice, which specifically refers to cases decided by national courts. And there is, this is referred to in page 41 of Brownlee's Principles of Public International Law, 8th edition, where he says very briefly, if I may read the sentence, Article 38, 1D of the Statute of International Court is not limited to international decisions. Decisions of national courts also have value. Decisions of national courts also have value. And specifically the question is answered, which you have raised in the little book written by, the title is Unconstitutional Constitutional Amendments. Unconstitutional Constitutional Amendments by Yaniv Rosnai, pages 47 to 70. The basic structure has spread in Asia from India to Bangladesh, to Pakistan, to South Korea, Japan, China, Taiwan, Thailand, Sri Lanka, Malaysia, and Singapore, and in Africa to Kenya, South Africa, Tanzania, and Uganda, although Uganda is not mentioned, but Uganda we have a case there, and then Central and South America, Caribbean, and it's my humble submission that this case or this decision has what we call the qualities of jurisprudence. Thank you, my lady. I urge you again respectfully, throughout this BBI appeal, let us forget about it and move on to something else in life.
Thank you. Thank you.
My Lord, the Chief Justice, the Deputy Chief Justice, Justices of the Supreme Court, my name is Stopua Lesinko, and I'm here to respond to Justice Isaac Lenaola's question on Article 368 of the Indian Constitution, as read together with the Kesavananda case. And as I understood, his argument was that Article 368 of the Indian Constitution gives Parliament almost what I can call unlimited powers in amending the Constitution. Let me first say that my import and my argument with regard to the Kesavananda case was in relation to the Attorney General argument that the High Court and the Court of Appeal erred in relying on that case, which actually is restricted on parliamentary amendment of the Constitution, is distinguished to the Kenyan current case, which was actually the issue of the referendum by the popular initiative. Let me go back. Just in India, the Golaknath case was the state of Punjab. I think it's a 1967 case. It was first held by the Supreme Court that some of the sections of the Indian Constitution, including fundamental rights, could not be altered. And coming back forward to the Kesavananda case, we have the majority decision read by Chief Justice Sikri saying that Parliament could not use its amending powers to alter or damage the Constitution. That leaves us in a situation where, despite the Constitution really giving unlimited powers to Parliament to amend, the Supreme Court, by all its rights, tends to limit. I think, and this despite references under Article 368 that seeks to host judicial review. So it was my argument then before this court that the Kesavananda case may not actually be relevant so much to the current appeal under consideration, on the ground that my reading of the High Court decision and the Court of Appeal, the judges were clear, I think under paragraph 172 Superior Court and the majority decision in the Court of Appeal, that the Constitution of Kenya is amendable. No immutable clauses, no eternity clauses, and therefore the argument by the Attorney General cannot stand on that issue because ours is amendable, unlike the Indian Constitution based on the holding in Kesavananda that Parliament cannot alter some of what is regarded as fundamental under the Indian Constitution. In that regard, it was my argument that the appeal then fails in trying to impute the High Court and the Court of Appeal decision on our reliance to the Kesavananda case, which I think is not really relevant. Thank you.
Thank you for those responses. We will now give time to the first appellant, the second and the third appellant to respond.
May I say something, my lady? My lady, can you permit me to say something?
Yes, Dr. Camino.
Yeah. My lady, I have an idea of the extent of the Supreme Court library and even the Court of Appeal library. Now, I have a number of books on this amendability, and I would be prepared to hand them to your registrar should you, any of the members of the court wish to have them. I have a book called Making Constitutions in Deeply Divided Societies. I have another one called An Amendable Constitution. I have another one called Unconstitutional Constitutional Amendments. I have another one called Constitutional Amendments. I have another one called Responding to Imperfection, the Theory and Practice of a Constitutional Amendment. I have another one called 6 Amendments, How and Why We Should Change the Constitution. I have another one called The Foundations and Traditions of Constitutional Amendment.
Thank you for the donation.
I'm prepared to hand them to the court. Should it be necessary, the registrar can get in touch with me.
Yes, we will borrow them to use and then return to you because we don't want to deplete your library. Subsequently, we will order our own copies if we don't have them in our library.
Your Ladyship, the Chief Justice, the legal team for the second appellant had requested that they do their response first, and the reason that they had requested was that so that whatever time they do not utilize for their response, subject of course to the court's convenience, they have kindly agreed to donate to us.
My Lord the Chief Justice, my Lord the Deputy Chief Justice, and my Lords the Justices of Supreme Court, good afternoon. My name is Justice Munyithia for a record. Happy to be before you. My Lord, I was last year in 2017 on an election petition, and this will be my maiden appearance before you since you were elevated to the office. My Lord, you had given us 25 minutes, and we had 5 minutes left. I'll take 5 minutes to respond to Morara's question, and my colleagues will respond to the other issues. My Lord, this question was raised by Justice Lanola yesterday, and my lead counsel, Professor Gedu, answered that the answer would be found in the decision of 208J as to whether the question of framing the referendum question was right. We have filed responses to that issue in that, and we have also put our written submissions. I will therefore highlight and say that we oppose that question with only one ground, that this issue was not live for determination. In doing so, my Lord, we realized that there was a definite finding by the High Court, and the Court of Appeal overturned or set that decision on page 8360 of the Record of Appeal. Why do we say that this matter was not ripe for determination? Lord, the only law that we have that governs the referendum in the statute books is the Elections Act, Section 49, Section 50, and Section 51. It is very clear that whenever questions of referendum arise, whenever those questions arise, there is step that must be taken. Now, there is no doubt, and Morara has not responded to this, that the process was stopped when it was still in the National Assembly and some of the county assemblies. It had not moved to the President, who, once he receives the bill, will now forward it back to the IBC to frame the question. So that when we were in the High Court and the Court of Appeal, that question was not ripe for determination. This court, and many other times, we have had judicial interpretation that the only time a court says of jurisdiction to interpret a matter is when that matter is in dispute and you don't agitate on matters that are likely to happen in the future. So that in raising that issue, or the High Court in trying to determine on that issue, there was speculating in the future what happens. Two, the commission, under Article 248, it's one of the independent commission. Under Article 249, it is not subject to control of any authority. We don't doubt that courts can intervene. But when the High Court is exercising its jurisdiction, one, it cannot exercise jurisdiction that is reserved of the Supreme Court. That is very clear in Article 165(5). 2, even if there was need to seek that supervisory opinion for purposes of that advisory opinion, then the matter can only be referred to by IEBC in the Supreme Court on the question of framing. So that when High Court pronounced itself, it would amount, 1, entering into the mandate of the IEBC in terms of framing the question, and that is rightly pointed out by Justice Toyot. 2, it will be exercising advisory opinion. Now, the other issue that I want to address is, can this court now interfere with the decision of the Court of Appeal as far as this matter is concerned? My Lord, likely put, this court now is exercising appellate jurisdiction under Article 163(4), and therefore it can only address the question raised. It cannot reserve or become an advisory or give an advisory opinion. So we submit that the questions that came before the court by the High Court itself, it was wrong because it offended the doctrine of ripeness. The Court of Appeal was right in setting aside that other point. My Lord, you cannot start counting your chicken and do the hatch. This is exactly what the High Court was doing. We urge you not to be tempted to move to that. We urge that you uphold the decision by the Court of Appeal on this issue. Thank you very much. I'll invite my colleague.
Good afternoon, my ladies and my lords. In a very quick rejoinder in relation to the question of public participation, I would want to draw, with your permission, the provision, the attention of this court, the provisions of Article 257, Subarticle 4. Reads, my ladies and my lords, that the promoters of a popular initiative shall deliver the draft bill and the supporting signatures to the Independent Electoral and Boundaries Commission, which shall verify that the initiative is supported by at least 1 million registered voters. My ladies and my lords, the reason I draw your attention to that provision is because our appeal is limited to that particular provision. And specifically, the IEBC did file an appeal in relation to a very targeted question, a question arising from the finding of, 1, the High Court, that the IEBC, in applying or interpreting the provisions of Article 257(4), is also called upon to confirm that the promoters of the initiative have conducted public participation. That was the first finding, and we did make reference to paragraph 577 of a decision of the High Court. Again, the second limb of our argument was whether the Court of Appeal was right in interpreting that Article 257(4) to mean that the IEBC should have actually been the one to conduct public participation. My lords and my ladies, our position then, as it is now, is that a true reading of that particular provision cannot yield any of those two meanings. Now, let me get back to the responses that I've heard from my learned friends. I've had two justifications. That, 1, the only two reasons why, in their view, the two findings can hold is that the IEBC has time. So that under Article 257(4), there is no time prescribed for it to be able to then forward the bill and the signatures to the county assembly. My ladies and my lords, that, in my very humble view, would be a slanted reading of that particular provision. The second reason they give is that IEBC is ordinarily expected to have money. Again, my ladies and my lords, that cannot be the reason we say that that obligation crystallizes on the IEBC. It is our submission, my lords and my ladies, that if, like I said yesterday and the day before, the process of constitutional review under Article 257 is incremental, and that it establishes several areas where public participation is to be done. And on this, I got support from my learned friend appearing for Muhuri, that is Counsel Christine. My ladies and my lords, she agrees with me that Article 196 speaks to how then the county assemblies are supposed to achieve public participation. That is a very important concession. Again, we made submissions and no one has contested it, that Article 94 and 95 provides for how public participation can be achieved. So, my ladies and my lords, that remains our submission, that a true reading of that Article 257.4 cannot yield the two meanings assigned to it by both the High Court and the Court of Appeal. My ladies and my lords, that said, I've also had submission, again from the respondents, which appear in one way or the other to want to expand the scope of our appeal. Our appeal did not touch on the question of verification of signatures. I've had lengthy submissions on that question. Please, my ladies and my lords, it is our submission that that component of the appeal should be disregarded because it does not flow from our appeal. Again, I've had submissions to the effect that the finding that there was no adequate legal framework is an issue that touches on public participation. With respect, my ladies and my lords, that does not flow from our appeal. That said, yesterday I did draw the attention of the court to your locus classicus, the decision in BAT versus CS Health. One of the principles under paragraph 96 of that decision is that every case where public participation is called, and that was this court applying the meaning of public participation that should be ascribed to Article 10, Subarticle 2, that at principle number 8, you say that each case is supposed to be looked at with the peculiarity of the circumstances in issue. It then follows that following that principle, one then does not read public participation in every article of the Constitution. And I'll give two examples. My ladies and my lords, today you sit to interpret and give meaning to this Constitution. That is what we have all come before you to do. Now, in the ordinary balance of the Constitution, one would be tempted to apply the provisions of Article 10, Subarticle 2, in relation to public participation. Would it not be turning logic onto its head to say that then, as you retire to do your judgment on this matter, then we call for public participation? I think that would be stretching the meaning of that particular provision. Second example, the AG, I think under Article 156, is the principal advisor to the government on matters law. Again, when the AG prefers an opinion to, say, His Excellency the President, one would not expect that the AG in conferring that opinion must then apply public participation. It is our submission, my ladies and my lords, that is the principle that you provided for under principle number 8 of your decision and authority in BAT versus CS Health. And that being the basis, I would also then want to submit, my ladies and my lords, you don't need any additional legal or statutory framework in relation to that question. My lords, I think that then would respond to the question of public participation, and permit me then to invite my lead counsel, Professor Githu Muigai, to respond to the question of the effect of constitutionality. I'm most obliged.
My Lady Chief Justice, judges of the Supreme Court, I'll be very brief in responding to three main issues. Issue number one is the issue of quorum. It would appear that there is a confusion as to the significance of this matter, which I think needs to be clarified. One group seems to argue the issue of quorum as if it has no consequence, as if a finding of no quorum has no consequence whatsoever, as if it were an academic matter. I think Mr. Justice Ouko, in one of his questions to us, sought to draw out that question of, is there consequence? We have had elections, 50 by-elections. We have had elections of the judge of the president of the Court of Appeal, elections of the justice, JSC's judges' representatives, and so on and so forth. This issue of quorum is not academic. It has consequences. Part of what was sought in the lower court was to find that part of the preparatory process leading to the election we expect in August, in a few months' time, was null and void for lack of quorum. So I want to suggest with the greatest possible respect that your lordships step back, take a deep breath, and worry a little bit about consequence. Number two, a question was raised again by the learned Mr. Justice Ouko. Is there some silence on the part of IEBC as regards the proposals to create constituencies and the compromise that may have on the IEBC's vested mandate? There is no silence. We are not embarrassed at all. We are only saying we appreciate that the Constitution is not cast in stone. Today we have a power. That power is well clarified. And it is a power to be exercised over a long period. But we have a constitutional moment in which the promoters of this bill feel requires a special intervention. That is not unconstitutional. And I'll give you an example, my lords. When we were involved in the post-2007-2008 problem, the Kofi Annan peace process, when we sat down, those who were helping in the background, there was a huge argument whether we could amend the Constitution then, because the Constitution said this is the Constitution of the Republic of Kenya and it stands above all other laws. One group insisted this is the Constitution of the Republic of Kenya and it is to be read alongside the Accord, and the Accord shall have equal force. Some people refused and said, no, you cannot do that. Eventually, that is exactly what we did. And all I'm saying is that there is a constitutional moment that may require a special constitutional intervention in the event that matter came and went, and we thank God for that. And finally, in the United States, for example, right now, there is a huge argument about expanding the Supreme Court. That argument arises because when President Trump was in office, he used that period to pack the court with Republicans. And now the court has swung dangerously to the right. And the Democrats are saying, let's add more judges to, and nobody has said that that is an illegitimate constitutional dialogue, that you cannot change that for any purpose. So it is our very humble submission that we have demonstrated that there was quorum at all material times, that the lack of a specific set of rules setting out quorum did not delegitimate IEBC. In fact, it's a question that cannot lie in the mind of any serious lawyer. You cannot say this constitutional commission is legitimate because to be legitimate it requires only 3 commissioners, but notwithstanding its legitimacy, it can make no decision because there is no law, because there is no law regulating quorum. I thought that most of my colleagues on this side who are championing democracy and the rule of law would remember when in this court we came many times and said we want to invoke the chapter of the Constitution on the defense of human rights. And the court then said, you cannot do that because the Chief Justice has not made regulations. I thought that is the jurisprudence we left behind us, not the one we are running to embrace. Thank you. I have 8 minutes left. I will donate this to the Honorable the Attorney General, who has the very weighty responsibility of guiding our nation.
My Lady the Chief Justice, my Lords, members of the court, I'm sure learned Senior Counsel Professor Gidu Muigai appreciates only too well the weight on the Attorney General's shoulders, having been the Attorney General himself. Members of the court, I wish to start the Attorney General's response by taking the opportunity to put on record the filings that the Attorney General has made in this matter. And the Attorney General filed a petition of appeal together with a record of appeal that ran to 47 volumes, both dated the 26th of September last year. The Attorney General has filed a supplementary record of appeal, and that supplementary record of appeal has 3 volumes, and that was filed and dated on the 25th of October last year. The supplementary record of appeal is accompanied by an affidavit sworn by Mr. Kennedy Ogeto, the Solicitor General, and that was filed on the 8th of November last year. The Attorney General has filed written submissions on the 24th of November last year, and supplementary submissions on the 14th of January this year. A bundle of authorities that run from volume 1 to 26, filed on the 24th of November last year. The Attorney General filed a supplementary bundle of authorities on the 14th of January this year. A further supplementary bundle of authorities also on the 14th of January this year. A case digest in respect of all the authorities that the Attorney General had filed, which was filed on the 24th of November last year. A supplementary case digest filed on the 14th of January this year, and a second supplementary case digest that is filed on the 17th of January this year. In respect of the appeal number 15, petition of appeal number 15 of 2021 before this court by Mr. Morara Omoke, the Attorney General filed grounds of objection to that petition of appeal on the 14th of October last year. The Attorney General wishes to rely on those grounds in opposition to the petition of appeal by Mr. Morara Omoke, and the Attorney General adopts the submissions and the authorities that have been filed in respect of that appeal by the Independent Electoral and Boundaries Commission, the second appellant before you in these matters. Your Ladyship, the Chief Justice, I wish to commence the Attorney General's response by stating that there is no contradiction in the submissions that have been made by the Attorney General in respect of the important matters of the basic structure and the basic structure doctrine. It is the Attorney General's submission that the basic structure is are the foundational provisions of the Constitution. These are contained in the provisions of the Constitution and are identified as entrenched provisions of the Constitution, and it is the Attorney General's submission, and I will justify later on in my reply, that the basic structure of the Constitution of the Republic of Kenya is contained in Article 255, Subarticle 1 of our Constitution. On the other hand, members of the court, it is the Attorney General's submission that the basic structure doctrine is an extra-constitutional theory which limits the power of amendment under the Constitution and applies to limit the power of secondary constituent power to amend the Constitution. So that is the difference between basic structure and the basic structure doctrine. Further, it is the Attorney General's position that it is the basic structure doctrine is outside the Constitution, but does not apply to the Constitution of the Republic of Kenya, as the sovereign power to amend the Constitution is contained in Article 1, Subarticle 2 of the Constitution of the Republic of Kenya. We submit that it is that our Constitution does not contemplate the basic structure doctrine. The basic structure of our Constitution is instead protected through the onerous amendment procedure stipulated in Article 255 of the Constitution. Amending the basic structure of the Constitution of Kenya requires approval of the people of Kenya in a referendum. The amending provisions that do not form part of the amending provisions that don't form part of the basic structure of the Constitution do not impose any such similar onerous requirements. In respect of why the Attorney General believes that the basic structure of our Constitution is located in Article 255, Sub-Article 1, we state that the reason why we state that the basic structure is located in Article 255(1) of the Constitution is the history of the Constitution-making process. In our submissions in chief and in our written submissions, at page 73 of the final report of the CKRC, the people captured the concern or their concern as follows. And their concern, and I quote, was how quickly and fundamentally, and I emphasize fundamentally, the independence constitution was amended. The report goes on to, this is to be found in volume 13 of our bundle of authorities. At paragraph 75, the CKRC then identified what the people's solution was. It states that a distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being put in place for amending the former entrenched provisions. The only justification for entrenchment is the historical context, and this would safeguard the core of the Constitution. Article 255(1) of the Constitution would only require a more stringent mechanism for amending the provisions outlined in Article 255(1) of the Constitution, because these provisions constitute with tremendous respect the core and therefore the basic structure of our Constitution. The amendment sought to be restricted by the wrongful application of the basic structure doctrine. We submit flows directly from Article 1.1 and Article 1.2 of the Constitution of the Republic of Kenya. We submit that when your ladyship and the other members of this court retire to consider your decision in this matter, if you take a moment to, whilst keeping an eye on Article 1, Sub-Article 2 of the Constitution, go through the provisions of Article 257 of the Constitution, and especially from Article 257, Sub-Article 5, you will find that the architecture of Article 257, Sub-Article 5 clearly demonstrates that the amendment by popular initiative, and it is that amendment that the basic structure doctrine has been deployed to obstruct, is an amendment by the people of Kenya and is an amendment by the sovereign. There was very heavy weather made of the distinction between the word amendment and alteration, and I believe it has formed, or it was the basis of one of the questions that was asked by one of the learned judges of this court earlier on this morning. And in response, we submit respectfully that there is no difference between the word amendment and alteration. It is a distinction without a difference. The High Court and the Court of Appeal only dwelt on the dictionary meaning of the word amend. It is our submission that the textual meaning of the word amend does not bring out the true meaning of the word amend as used in Chapter 15 of the Constitution of the Republic of Kenya. 16, I'm sorry, not 15, Chapter 16. The contextual meaning of the word amend, as used in Chapter 16 of the Constitution of the Republic of Kenya, connotes the ability of the sovereign that flows from Article 1.1 and Article 1.2 of the Constitution of the Republic of Kenya to make or unmake anything. That is an accepted ability of the sovereign. That is what sovereignty is. And the word amend is then used with that special meaning in the Constitution to then give the sovereign the ability to make or unmake anything in their constitution. There is no textual or contextual justification for the importation of the basic structure doctrine into the Constitution of Kenya, despite the express provisions of the Constitution. There was an argument made by, I believe it was 254 Hope, that anything could be implied into the Constitution as long as the Constitution does not prevent it from being implied. We respond to that respectfully by saying that that cannot be the law. There is no justification for importing anything into the Constitution. The Constitution is clear, and it does not then lend itself to the importation of any these principles and doctrines that were imported into it by the High Court and the Court of Appeal. I then wish to respond to what is the source of the President's authority to initiate amendments to the Constitution. At a general level, the President is a citizen like other citizens. He therefore enjoys all the rights and fundamental freedoms of all other citizens. These include equality before the law, the equality before the law, and the right to equal protection and equal benefit of the law, Article 27 of the Constitution. Freedom of conscience, religion, belief, and opinion, Article 32, and freedom of expression, Article 33 of the Constitution. Political rights that include the right to campaign for a cause that is provided for in Article 38. In exercise and pursuance of these rights, the President may and can initiate or support amendments to the Constitution. In any case, as was the case in the present instance, some of the functions of the President provide him with the opportunity to initiate and or support amendments to the Constitution. For instance, Article 131 of the Constitution confers upon the President certain functions, the performance of which may potentially include amending the Constitution. The President may initiate and or support amendments to the Constitution in order to, 1, safeguard the sovereignty of the Republic, 2, promote and enhance the unity of the nation, 3, promote the respect for the diversity of the people and communities of Kenya, and lastly, ensure the protection of human rights and fundamental freedoms and the rule of law. Those we submit are constitutional functions of the President that would of necessity enable him to initiate amendments to the Constitution. The next issue I wish to respond to are the submissions that were made in respect of public participation, and public participation in particular in respect of the process of amendment by popular initiative under Article 257 of the Constitution. I wish to submit that it is the Attorney General's position that Article 257, read in its totality, from sub-article 1 to sub-article 10, is replete with opportunities for public participation. If Article 257 were let to run its course, I submit that public participation would have taken place effectively. I submit with tremendous respect that if it is the court's finding, or if it was the finding of the High Court and the Court of Appeal, that public participation did not take place, then the only reason why public participation did not take place is because the course of the process of popular amendment via Article 257 was stopped by the court. If the court gave the process the opportunity to run its course, public participation would have taken place. I wish to respond briefly on the submissions that have been made on the ground of appeal of presidential immunity. And there was a submission that in asserting immunity and claiming political rights, or in asserting absolute immunity and claiming political rights, the President of the Republic of Kenya was trying to have his cake and eat it. In response, I wish to submit that following the Bellevue case that was cited severally by my learned senior Mr. Waweru Gatonye, judges of this court enjoy absolute immunity. It is not lost on any of us that judges of this court have severally commenced proceedings in the High Court and in the Court of Appeal to assert their rights under the Constitution. Absolute immunity does not take away a party's rights under the Constitution. It is not a trade-off. You can have absolute immunity under the Constitution, and your rights remain alive for you to enjoy and assert as you choose to. The absolute immunity extended to the head of state under the Constitution of this Republic, as was submitted by learned counsel who appear for him, is for the purposes of enabling him to discharge his functions as head of state effectively. In respect of the constituency question, we associate ourselves with the submission by Professor Githu Muigai, Senior Counsel for the IEBC, and that submission is that the contents of a bill to amend the Constitution under Article 257 are beyond the court. And we say so for this reason. I have stated earlier on in my response that the amendment by Article 257, as opposed to the amendment by Article 256, is by the sovereign. It is by Article 257 that the sovereign retained the right to amend their constitution. And I submit in response that the contents of that bill is beyond the court's ability to review or pronounce itself as to its constitutionality. That right or that ability flows from the ability donated by the people of Kenya, or vested by the people of Kenya by the High Court, by Article 165, 3D, Roman 2. I want to give an example, or I want to demonstrate the submission that I have just made. And I wish to refer your lordships to the 6th schedule of the Constitution, and in particular, sections 23 and 24 of the 6th schedule. The 6th schedule forms part of the Constitution. And at section 23, the people of Kenya, when they promulgated this Constitution, created a procedure for the vetting of judges. And they created a procedure for the vetting and removal of judges. Judges who enjoyed security of tenure, judges who held office properly under the previous Constitution. The Constitution, again, at the 6th schedule, at paragraph 24, provided for the retirement of the last Chief Justice under the former Constitution. That Chief Justice held office constitutionally, and if these two provisions were subjected to the scrutiny that the Court of Appeal subjected to the provisions that the people of Kenya had made in the bill, for example, about the Judicial Ombudsman, then no doubt these two provisions would have been found to be unconstitutional. The point I make is that when the people of Kenya sit to determine the content of their constitution, then they are completely free to determine the content of the bill. The role of the court then is to determine procedural compliance with the provisions of Article 16. Of Chapter 16. And once the court is satisfied that the initiative has complied procedurally with the provisions of Chapter 16, then it leaves the content of the bill to the people of Kenya, to the sovereign, to the owners of the Constitution, to determine what they want to amend and the shape and terrain of their Constitution. That is all I wish to respond, and I wish to yield the rest of my time to my learned senior, Mr. George Orando, Senior Counsel, who wishes to make a few comments in the time remaining.
Thank you, the Chief Justice, the Deputy Chief Justice, and members of the bench. I have only one issue I wish to clarify, and that is in the context of the 4 sequential steps which were prescribed by the High Court to be undertaken before the primary constituent power can be deemed to have been exercised. It was indicated to you that these 4 sequential steps might have been derived from the book by Professor Nabweze, but the fact is that these were contained in the Constitutional Review Act and an amendment to the Constitution, the repealed Constitution, which led to the constitutional review process. And what the learned judges did without expressly stating so is that they were trying to revert to the original ratification procedure as a basis of legitimizing the process of amendment to the Constitution, having acknowledged that our Constitution is not unamendable. It is. And the issue they were addressing there was how can it be done? And they thought that the best way of doing it is to apply the basic structure doctrine and go back to the process we followed in making the current Constitution. Now, the power of making the Constitution is primordial and is vested on the people and cannot be restricted or regulated either by law or by a court.
On your left of your screen, we have the Supreme Court proceedings for the BBI case continuing, but we do interrupt that live coverage to bring you another live coverage. As you can see on your screen, that is His Excellency President Uhuru Kenyatta live. He has just gotten to the National Police College main campus in Kiganjo, where he is expected to officially preside over the passing out parade for direct entry inspectorate course, where 298 will be graduating today and being inspectors. We have our team on the ground. We also have Timothy Kipnusu, who has been camping there since morning, and His Excellency is just alighting from his official vehicle where he is expected to inspect a guard of honor.